same thing with Justice Adume.
I don't know whether they have.
National honor. Okay. Wait, file. PhD. Wait, file.
Let people take their seats.
Let me. My name is Falak. Okay. How are you? Hello. Good morning, everyone. My lords, I'm told it's 10 o'clock, and about time we call the house to order. Even as I struggle to tell my lords that I see now. A very good morning, everyone. Yes, gives me great honor and a distinct pleasure to be here to anchor the public lecture designed as one of the programs, taught as one of the programs to mark the 2024-2025 legal year of the National Industrial Court of Nigeria. Yesterday was the court ceremony, court sitting, the new legal year open. And today is being dedicated to both a public lecture and an opportunity for the users of the court or the stakeholders to come and ask my lord, although at the risk of sanction of content, get the opportunity to ask my lord questions. So as opposed to my lords raising questions so much when we're in court, lawyers, litigants, and all stakeholders will get an opportunity to pose questions to my on what the court at this junction. Permit me to start with the rendering a national anthem before I go on to the introduction of the chairman and the guests. Yes.
Nigeria,
all right,
will be our own dear native land, though tribe and tongue may differ, in brotherhood we stand. Nigerians all and proud to serve our sovereign motherland. Our flag shall be our spirit. justice reign, in peace or battle honored, and this we count as gain. To hang unto our children a banner without stain. O God of all creation, grant this our one request. Help us to build a nation where no man is oppressed, and so with peace and plenty, Nigeria may be blessed.
Thank you very much. You can take our seat. I recognize that there's a lot to learn for today, and the time is we are well behind time. So let me go straight to the introduction of the chairman and the guests. It's an honor to have in our midst a retired, but evidently not tired, Justice of the Supreme Court. My Lord, the Honorable Justice Ejembe Eko JSC. Thank you. Still within our midst, it gives me great honor to recognize the Honorable Justice Abraham Moore Hadume, serving Justice of the Supreme Court. Still following that order, I struggle, but I think the proper thing is to recognize first the immediate past president of this great court, my Lord, the Honorable Justice Adejumo. I hasten to use retired because obviously my Lord is not looking tired. Our great host, the president of the court, the Honorable Justice B.B. Kanye, PhD, OFR. We recognize. And there's one gentleman who doesn't look the color of his pen. For those of us who have religiously followed him over the years, and I say over the years, before he walked in the corridors of power, who is our guest lecturer today, my Lord. I'm tempted to actually call my Lord as well, Mr. Lisheru Aderi. Well, he's a lord in the newsroom. Yes. I also recognize in our midst, my Lord, the Honorable Justice Oyewumi JCA. The justices of this court, permit me to perhaps, without mentioning all the names so that we do not spend the whole of today, we recognize and we thank you, my lords, for being part of this as well. A round of applause for my lords here. I also see in our midst the Honorable Justice Bamudu of the FCT. Thank you, my lord. Well, it's an assemblage of, a rich assemblage of eminent jurists and legal practitioners. I cannot miss Mr. Kutekwa SAN. Thank you for being with us, sir. My Lord, Leonard, brother, sick you're not. A very young son, Mr. Daudu SAN. Thank you for joining us. Where's the double out of being the chairman of the Bari branch of the MBA? Well, as it progresses, I would also take time to recognize the great personalities in our midst. Without much ado, permit me to invite to the podium, this part of the podium, the Honorable Justice Ejembe Eko JS retired for the chairman's address. My Lord. Oh, sorry, welcome remark. Yes, this works.
My welcome remark?
Yes, you're welcome remark. The chairman's welcome remark.
My lords, ladies and gentlemen.
Sorry, sir. Sorry. Apologies.
Okay.
I think it's the chairman. Oh, sorry. Yeah. My Lord,
I'm going to sit.
I am so sorry, my Lord. I just got used to the order of calling justices of the Supreme Court before calling on the president of the court. I apologize for that breach of protocol. It is actually the welcome remark by the Honorable President of this court, the Honorable Justice Bibi Kaim, that follows next.
My Lord, the Chairman of occasion, Honorable Justice Ejembe Eko, retired Supreme Court Justice. My Lord, Justice A.M. Adumien, Justice of the Supreme Court. My Lord, my predecessor, Honorable Justice B.A. Adejumo, OFR. My lords of various jurisdictions, I can see Justice Diko, I can see Justice Bamudu, Federal High Court, FCT, I can see our representative yesterday, who ably represented the NBA president. I can see learned SANs, SAN Okutepa. Permit me to congratulate Daudu behind you. I'm seeing him for the first time since his swearing in. I can see distinguished guests who are here, and of course, management and staff of the National Industrial Court. And I reserve recognition to Mr. Segun Adeni, who graciously accepted to be our public lecturer today. As I welcome you all to this special court sitting, which is physical and virtual, to mark the 2024-25 legal year celebration, I must thank God Almighty for making us witness the said celebration. And so on behalf of all judges, management, and staff of the court, kindly accept our gratitude for honoring our invitation. This year's legal year celebration, the third in the annals of the court, is themed Labor, Justice, and Public Interest. The public lecture under the same title is being delivered by no less a personality than Mr. Olusegun Adeniyi, an accomplished journalist and author, current chairman of the editorial board of this day newspapers, and a former presidential spokesman to the late President Umaru Musa Yar'Adua, GCFR. Following on the public lecture would be our second bar bench forum. Both the public lecture and the bar bench forum expectedly are a sort of referendum and feedback on our performance as a labor court over the years, especially from those who use our services. We are taught that, sorry, I think I'm having the wrong, sorry, I had the wrong speech. I crave your indulgence to start all over. I welcome you all, physical and virtual participants, to this public lecture / bar bench forum. The public lecture is the third held since my assumption of the headship of the court, while the bar bench forum will be the second. The first public lecture we had as part of activities of the 2020-21 legal year took place on 6 October 2020 with the theme Dignity of Labor and Labor Justice. And Most Reverend Dr. Matthew Hassan Kuka, the Catholic Bishop of Sokoto Diocese, was our guest speaker on same topic. The second was delivered on 6 October 2022, and the theme was Labor Justice and Socioeconomic Development. The public lecture was delivered by Her Honor, Honorable Justice Deborah Thomas Felix, the then President of the Industrial Court of Trinidad and Tobago. She spoke on the role of industrial courts and international labor standards in promoting good governance to support economic and social development. Today's lecture is on labor justice and the public interest, to be delivered by none other than Mr. Olusegun Adeniyi, whom I had earlier introduced. Having followed his writings over the years, a chance meeting with him through my classmate and friend, Mr. Bello Mohamed Adoke, CFRSAN, former Attorney General of the Federation and Minister of Justice, sparked in me the desire to have him speak to us in this year's legal year celebration. I accordingly asked him, and he agreed to give the lecture. For this, we are most grateful. The lecture and bar bench forum is chaired by a very respected jurist, His Lordship Honorable Justice Ejembe JSC retired, in an era of leading dissenting opinions on the bench. What His Lordship was honored with on his retirement was a public presentation of the book titled Honorable Justice Ejembe Dissents, a collection and comments on His Lordship's dissenting judgments at the Supreme Court of Nigeria, edited by Chief Ogu James Onoja, SAN, and Yeye Fumi Kadri, SAN. Known for his principled stance on issues, we thought it fitting for His Lordship to chair today's session. We are grateful His Lordship accepted. For us at the NICN, there is an additional reason for inviting His Lordship. We remember His Lordship's decisive words / stance in the leading judgment on the jurisdiction of this court in Coca-Cola Nigeria Limited versus Akisonya. The question was whether the NICN's exclusive jurisdiction as to employment under Section 254C1 of the 1999 Constitution included private employment or master-servant relationship. You will wonder why such a mundane issue, one that a first-year labor law student knows the answer to, be in the affirmative, should even be raised at all, not to talk of it being the subject of a case stated to the Supreme Court. But it was indeed raised by a very senior counsel, and it did get to the Supreme Court for resolution. His Lordship, our chairman today, had the burden of resolving the issue. He did, answering the question in the affirmative, and that paved the way for the NICN to be what it is today. The labor justice we deliver to especially employment relationships in the private sector is because His Lordship answered truthfully that the word employment as used in Section 254C1 of the 1999 Constitution meant both public and private employment. Once again, we extend our gratitude to His Lordship for his steadfastness and fidelity to the Constitution and the law. We have continued in the tradition of retaining labor justice in our legal year themes, since that is our core mandate, which conforms with our motto, the bastion of labor justice. Of course, the sub-themes over the years have differed. Dignity in labor in 2020, socio-economic development in 2022, and public interest in this year. The public backlash on the judiciary has of late been on the increase, as judicial bashing appears to be a pastime. The judiciary now is like the ocean where the debris of rivers is dumped. And because the rivers are not dredged, the ocean becomes the dumping ground or a dumping site. As we all know, cleaning up the ocean can be a very daunting task. We at the National Industrial Court of Nigeria have not been spared. In the keynote address I delivered at the 2024 NLC and TUC pre-May Day lecture on 29 April 2024 at Olaiton Oyirinde Hall, Labour House, Abuja, under the title Labor Laws and Trade Unions in Nigeria, I noted thus at paragraph 5, and I quote, "We at the NICN have been variously accused. Government complains that they have unnecessarily lost so many cases at the NICN. In fact, the former governor of Kaduna State, Nasir El-Rufai, said we specialize in freeing crooks, and that government made a mistake to establish the NICN. Employers and their lawyers think that the NICN is an employees' court, and labor on its part have accused us of being pliant judges, compromised judges who grant jankara and black market injunctions. So if the three stakeholders, stroke social partners, government, employers, and labor, all complain about the NICN, does it not show that we are simply doing our work? After all, Lady Justitia is blind." Unquote. I only paraphrase what the immediate past governor of Kaduna State said. His full remarks were actually on 1st February 2023, where on Channels Television he said that the Nigerian judiciary is pathetic, too slow, and often on the side of crooks, rather than on the side of government or the innocent. Before concluding that one of the greatest mistakes ever made is the creation of the National Industrial Court, which sees its duty as taking sides with the employee against the employer, ruling against employers in favor of criminals. Given that courts are independent of both the legislature and the executive arms of government, and by Section 6, subsection 6B of the 1999 Constitution, judicial powers extend to all matters between persons or between government or authority and to any persons in Nigeria, for which none is to be favored over the other. What does it mean with the assertion that the Nigerian judiciary is not on the side of government? Was the judiciary set up to be on the side of government or to deliver justice? Now that he is before the court, which he labeled a pathetic institution, for the enforcement of his fundamental rights against the Kaduna State House of Assembly and the Kaduna State Government over allegations by the House that 423 billion naira was diverted during his 8-year administration as governor of the state. Going by his logic, should the court side with government? The charge that we grant indiscriminate ex parte orders restraining labor from embarking on industrial actions forgets that we grant them as a matter of course where the industrial action is yet to commence. And to both private and public employers, we do this given Section 71B and 19A of the National Industrial Code Act 2006, which empowers the NICN to restrain any person from embarking on a strike and the grant of urgent interim reliefs, and Section 18(1) of the Trade Disputes Act 2004. The accusation that the NICN is an employees' court is historically not incorrect. This is because labor law itself, the very subject matter of the NICN, is a product of the uneven bargaining power between employees and employers. And so I must acknowledge that labor law itself admits of a good deal of paternalism, which has seen conscious effort being made to safeguard the interest of the worker. The International Labour Organization, ILO's decent work agenda, is a pointer to this. Back home, as far back as 2014, the Court of Appeal in Afrap Chemical Limited versus Pharmacist Owodwenyi, for instance, held that courts should not allow the imposition by employers of servile conditions on employees. The paternalism of the law, however, has not beclouded our sense of justice and fairness to all litigants at the NICN. For there are cases in which the employer did not even make an appearance, or for one reason or another failed to enter any appropriate defense, and yet the employee lost. In Mr. Ige Adediran versus Arik Air Limited, for instance, the claimant sued against his summary dismissal and prayed for reinstatement. His case was dismissed for lack of proof, despite that the defendant did not enter any appearance or file any defense process. And in National Pension Commission versus Tradeways Express International Limited, there was no legal representation for the defendant, a company. Yet, the case of the claimant, a government agency, was dismissed. I need to draw attention to a point. Employment rights are in the main rights in rem, as distinct from rights in personam. Employment rights are in the main rights in personam, as distinct from rights in rem. I am not unmindful of the school of thought in labor/employment law discourse that see especially the employment right as to security of tenure as one that is a proprietary right and so is one in rem. This aside, we generally view employment rights as rights in personam. And so, public interest litigation by especially civil society organizations, non-governmental organizations on behalf of employees that should have themselves sued have generally been frowned on and denied competence on the ground of absence of local standard by this court. This was the case in the Incorporated Trustees of Initiative on Education for Global Growth versus National Broadcasting Commission and two others, an Association of Legislative Drafting and Advocacy Practitioners versus President of the Senate, National Assembly, and 8 others. Reminiscent of that biblical question by the good Lord himself, who do people say I am? And which was followed by the second, and who do you say I am? I took out time to ask for the impression of people, especially in the social media about the NICN, I was given a handful from Twitter and Facebook, which turned out to be positive reviews of our work and impact. They range from we are, and I quote, the best court and perhaps one of the best public agencies in Nigeria, unquote, best court system in Nigeria by a mile, we are doing well, we have really taken the bull by its horns in broadcasting proceedings to the general public. 2, NICN has always been on the path of justice, especially for the workers, and the most progressive institution in Nigeria. 1 even intoned, it feels like this court is not a Nigerian court, so advanced. So, I leave it to you, whether as a labor court we have outlived our usefulness, as the immediate past governor of Kaduna State seems to entreat, or we are on track. I say this with all seriousness, especially as the current National Assembly had kick-started the process of altering the Constitution, where drastic suggestions are being made to alter the constitutional provisions that relate to especially the judiciary. Like I pointed out yesterday in my legal year speech, for us at the NICN, we are contented with all the constitutional provisions relating to the NICN as they are, and so we urge that they be left intact and untouched. And so, as we all ruminate over the NICN and its constitutional mandate, I invite you to savour the lecture of today. I thank you all for your attention as I once again welcome you.
Yes, yes. A round of applause again for my Lord. As my Lord made what was supposed to be an opening remark, I thought to myself that maybe there was a reason why there was that deliberate breach of protocol in not having my Lord come up first. I didn't want my Lord to preempt Mr. Olusegun Adeniyi's paper because I wouldn't know why the court decided to have Mr. Adeniyi, but I've always thought that, well, I hope the court will not encourage Mr. Adeniyi to walk into what may amount to contempt in the face of the court, because I'll leave it at that. I'll come back to that later. Again, my Lord, thank you so much. At this stage, permit me to now invite to the podium the Honorable Justice Ejembi Eko, JSC, for the chairman's address.
My Lord the President, or Your Excellency, the President. My Lords here, the Honorable the Speaker, my Lords, ladies and gentlemen, I've never been very good in protocol. I gaffed when I was General, and since then I don't embark on repeating it anymore. So please accept, ladies and gentlemen. I acknowledge all the existing protocols and I adopt them. Mine wouldn't be as elaborate as the President's speech, opening remark, which appears to be a statement of defense. And not many people understand the court system, not to talk about specialized courts like the National Industrial Court. At times you have to pardon them, but when it comes from very high echelon of the society, one begins to wonder how. They all believe that courts exist only to placate the government, and that the citizens are not to be reckoned with, but they have forgotten the very fine words of Section 36, subsection 1 of the Constitution in determination of his civil rights and obligations, including disputes against government and any authority, the party shall be entitled to fair hearing within a reasonable time. Those who are lording it on others do not see that equality of rights and obligation in the determination of civil rights and obligation, the quality of the rights of government qua the other disputant. The equality of rights and obligations is a constitutional norm and a right of all parties in court. Government, a litigant, is a party, and the individual in dispute with government is also a party. Equality before the right, before the law, does not exist only for us to always cover the tracks of government. And then one begins to wonder, some governors, the attitude to litigations against government is that judiciary is a department. That attitude has since gone. The judiciary is no longer a judicial department that it was during the colonial times. Since the 1963 Constitution, this issue has been prominently resolved. Government is, yes, separation of powers, executive, legislature, and the judiciary. The tripod makes government, but then each of them has its own autonomy and freedom. While one shall not operate to defeat the rights and duties of the other, so also every arm of government should recognize the autonomy of the other. I'm not sure I would go into, I don't want to be tempted to go into, to preempt what the speaker might be having in his kitty. But let me restrain myself a little by veering into an entirely new. When the Court of Appeal used to be here, it was a rickety environment. And now, look at the edifice we have. I give honor, glory, and appreciation to the founding fathers of this court. And His Excellency Adewumo is here. I've been wondering why Adewumo has never been blowing his siren. And Kanyip also says that we didn't have, so, but there are presidents. There are only, how many presidents we have in the country? One is judicial president and the other is executive. So, congratulations. The growth of this court has become very phenomenal and very rapid too. And now, the court exists in all the states, thanks to all the founding fathers of this court and those, the incumbent now. And thank God, you have never had industrial dispute with your staff. So, and I wonder if you had industrial dispute with your staff, who is going to resolve it? And then maybe that will take us into doctrine of necessity that was decided when the judges of Saskatchewan, Canada, had a dispute with over whether their taxes should be paid, should be deducted, and whether that deduction is not tantamount to, reducing it to their emoluments, reducing it to their detriment. There was no other person to take the court, so take the dispute, and it has to be decided. So the chief judge of the state had to preside over. Now, like I said, this is an industrial court, and the industrial court is a federal court. It's there in the Constitution. It's a federal court. It now exists in all the states. Maybe the next we'll be talking about is they are going to exist at the local government level. But let me not preempt any jurisprudential argument. I'll leave it at that now. Whether, because they are federal, whether labor is concurrent or exclusive legislatively, it's not I'm not talking about it today, but think about it. Then talking about the governors, and all the court is always siding with the labor. And the same governor wearing the same shoe subsequently. I will summarize it in the opinion of Spiro Agnew, American Vice President. When he was impeached, he says, until you are in the valley, you will not know the magnitude of the mountain. So now that the governor is in the valley, he will know how powerful this court is, and he will know where the flag is being hoisted. Like I said, let me not spoil the main menu. I'll stop here. I'll congratulate the management and the staff of this court for everything you have done. Right from starting as a rickety court, it is now a court that must be reckoned with. And it is no other than thanks to the ability to manage resources and manpower. You are great. Congratulations. Thank you very much. To save time, I will introduce the next speaker. And let me just trace, he sent it to me just now. He's no other person than Olusegun Adeniyi. Come again. Okay.
Yes.
Now, I think I have the responsibility in administrative law to delegate some of my functions. And I hereby delegate to the next speaker.
Well, my Lord, again, a round of applause for the Honorable Justice Jemie. Of the many beautiful things my Lord said, my Lord wondered aloud if an ex-employee of the court decides to take the court to court, and a current employee decides to take the court. And I can tell my Lord that as lawyers, practitioners before this court, we are waiting to read that. And what the reason is, a few times when lawyers have been taken to this court, at least I know about 3 judgments where this court took swipe at lawyers that we are supposed to know that this is the face of labor jurisprudence, and that unfair labor practice should not even be found in our domain. I'm not saying that he is in this court, but we're just wondering if this court, an employee of this court, decides to take this court. We are waiting to read what the court will say. Oh, I understand that I meant. Okay. All right, my Lord, we'll look out for it. Thank you so much, my Lord. Before I go and introduce the guest lecturer, let me recognize, I said earlier on that it's an assembly of eminent jurists, personalities. It gives me great pleasure to recognize the Honorable Justice Azan Diko of the Federal High Court. My Lord, thank you for joining us. Well, just yesterday, the learned Silk had mentioned to me that she would want to come and do more of industrial court matters, and I should perhaps create some space. And I said, no, you have enough space, or many spaces already. I recognize, and I see that truly she's there again. I recognize Victoria Awumolo, SAN. My Lord, let us say. Still within the same, I also recognize Mr. Anthony Ujo, the chairman MBA Gariki branch. Mrs. Bola Tumi Anima Shaun, who yesterday heavily represented the MBA president, but today she's representing herself, this MBA second vice president. And still ably representing the president of the bar. Thank you so much. We also have in our midst the president of the Chartered Institute of Personnel Management, Malam Ahmed Gobi Esquire. Malam, good to see you. Mrs. Ogochukwu Egbonu, who is the national treasurer of the Institute, CIPM, and Ms. Oluwatoyi Naiwu, the registrar of CIPM. Thank you so much for joining us, man. All right, so let me introduce the guest speaker. I said earlier on that I wouldn't know why he's been invited, because I know that he has a fairy pen. And with his fairy pen, you can be rest assured that he's made and continues to make trenchant criticism of the wrongdoings, of the ills, of the eroded value in the society in general, and in all spheres of life or sectors in particular. He's not spared even the judiciary. He has not. Because I remember in 2018, writing at the back page of this day, this is what this is what Mr. Adeni wrote on a topic titled, "When Judges Imperil Democracy." And I'll just take a few excerpts from it. And, he had gone on to say in that particular column that it is because judges now determine who wins election in our country that has encouraged all manner of electoral petitions from politicians. It is because judges now determine who wins election in our country that has encouraged all manner of electoral petitions from politicians, including those who may not have participated in the process beyond filing papers. But it would be unfair to blame our judges for the aberration, since they only deal with cases brought before them, though there are ways in which they increasingly become the problem. This was 2018. At about this time last year, he wrote something on what he titled "The Temperament of a Judge." And again from it,
You want to set me up?
okay, I will spare you on that and I'll just go to it. Because it was hard on our judges, it was hard on the judiciary. And basically maybe also telling it as it is in a no holds barred criticism, reflection of what is wrong in the polity. But it's not my session, and let me not preempt the paper, and I'll go ahead to introduce Mr. Olusegun Adeniyi. Sorry, just a minute. Journalist, writer, and former presidential spokesman, Olusegun Adeniyi is a fellow of the Nigerian Academy of Letters and fellow of the Nigerian Institute of International Affairs, who has written several books, including The Last 100 Days of Abacha, Power, Politics, and Death, a front row account of Nigeria under the late President Yar'Adua. I mean, that was the text that I remember that sold. And there was a time when it was a common feature driving through the traffic in Lagos. I mean, there's somebody brandishing it against your glass or your windscreen that, oh, you must read this. Against the run of play, how an incumbent president was defeated in Nigeria, from frying pan to fire, how Nigerian migrants risk everything in their future search for a better life in Europe, and naked abuse, sex for grades in African university. A founding member of the National Stakeholder Working Group of the Nigerian Extractive Industry Transparency Initiative. Adeniyi served on the panel of judges for the Nigerian Breweries PLC Maltina Teacher of the Year for 2015 and 2016. So I see where I kept referring you to as my Lord. Informally, you had served. You continue to serve as a judge. In 2019, he was inaugurated along with others from 29 countries as a council member of the Belt and Road News Network in Beijing, China. Adeniyi holds a first degree in international relations from Obafemi Awolowo University, Ile-Ife, and a master's in international law and diplomacy from the University of Lagos. He has also participated in several professional and academic programs in many countries. Notably, in July 2007, he attended the International Visitor Leadership Program organized by the U.S. State Department in Washington. He also spent the 2010-2011 academic session as a fellow at the Weatherhead Center for International Affairs, Harvard University, where he conducted his research on the factors that shape incumbent presidential elections in Africa. Married with 3 children, Adeniyi is currently the chairman of the editorial board of the Tuesday newspaper, where he writes a weekly column, The Verdict. Ladies and gentlemen, it's my honor, a privilege to invite on this part of the podium, Mr. Adeniyi, our guest lecturer. A round of applause.
The chairman of this occasion, Honorable Justice Jembi Eko. I mean, I said it would have been, maybe I would have killed a cow if he had introduced me. Fathers don't introduce sons. The president of this court, Honorable Justice Benedict Kanyi, he told the story of how we met, but he didn't tell the complete story. I will tell the story. I'm also delighted to meet Justice Babatunde Adejuwon in person. I met you through your judgment. You will also see that in the course of my presentation. Justice Admoye, let me also specially recognize my sister, the editor of This Day Law, Onikepo Braithwaite. I think I saw her. I saw her. And then our mommy, Mrs. Awomolo, another MBA officials here, distinguished ladies and gentlemen. I feel nervous being here in front of judges and lawyers. But I don't think I can be as nervous as one judge of a small town. That was a case which many of us are familiar with. So they brought this woman as witness. And then the arrogant lawyer approached her and said, Madam Abalaka, just the name. Do you know me? And I said, of course I know you. I've known you since you were a kid. You were troublesome. I don't even know how you graduated from university. You spent 10 years in university. You were in court group. How many people you killed, we don't know. So this lawyer was shocked. Then, after some time, gathered himself together. I said, do you know the defense counsel? He said, I know him. He's even worse than you. A criminal of the first order. He has had abortion for more than 10 women, including your own sister. When the lawyer gathered himself together and was looking at the bench, the judge just shouted, banged his gavel and said, case dismissed. The smart judge did not want the crazy woman to read the citation in the open court. I consider it an honor and a privilege to stand before this august gathering as we celebrate the 2024-2025 legal year. I expect many of you will be wondering, what qualifies me to be here and why a journalist is presenting a paper on labor justice and public interest? Perhaps I should let you in on a secret. I was invited to speak when I met an energetic man playing ping pong, that is table tennis, sometime last year. Had I not been introduced to the gentleman before I watched him toss the ball upward with his left hand and strike it fiercely with his right, it will have been difficult for me to believe that he was the Honorable Justice Benedict Kanye, President of the National Industrial Court of Nigeria. Considering the skills he displayed while serving and returning with spins and drop shots, it was apparent that the eminent jurist is not just good at playing the game, but he enjoys doing so. Even though we exchanged contacts, I decided not to dwell too much on the promise because I thought it was one of those spur-of-the-moment decisions people make when in a jolly mood. But earlier this year, the Honorable Justice followed up with a call to remind me that I will indeed be the speaker at this year's conference. I cannot thank you enough, Justice, for this honor. Let me also appreciate other judges of this court. This assignment has certainly enriched my understanding of the contributions of the NICN to labor jurisprudence in our country. To prepare my paper, I spent considerable time at the court's library. And as it is with most libraries in Nigeria, the environment could be better. But I was fortunate to encounter two dedicated library staff who painstakingly provided me access to relevant materials, including Digest of Labor Cases in Nigeria, 1960 to 2012, edited by Oluwole Kehinde, with a foreword by former president of this court, Justice Babatunde Adejumo. These materials and a few others I browsed through catalog hundreds of cases decided by this court to advance the cause of justice for workers in Nigeria. I've been asked to speak on labor justice and public interest. There could not have been a better time to interrogate this topic in Nigeria, as both labor and government were recently locked in negotiating an appropriate national wage, the lowest amount of salary that employers of labor, whether in the private or public sector, should earn in the country. After much drama, it is gratifying that the two parties were able to reach a consensus on the issue, despite the fact that the agreed amount cannot even buy a bag of rice in the market. So pitiable is the take of the Nigerian worker that it pays in comparison to what workers in Ghana, Kenya, South Africa, and Angola earn as remuneration for their work. The situation of workers in Nigeria is further complicated by the fact that those in the informal sector are practically excluded from any form of labor justice. Today, the only avenue for redress for most is to appear on radio programs. That is how Ahmed Issa, an activist and on-air personality who anchors Brekete Family on Human Rights Radio, has become not only the ordinary president for the vulnerable of our society, but also their Chief Justice. Such is the flagrant violation of workers' rights by all levels of government and the private sector that even foreign-owned entities operating in Nigeria have been emboldened to treat them with disrespect. In clear breach of extant labor laws, many of these companies resort to unwholesome practices that deny their Nigerian workers job security and appropriate benefits. Even where there are statutory compensation provisions for work-related diseases, injuries, disabilities, or death, they are mostly observed in the breach. In several cases, affected workers or their next of kin receive little or no compensation for death or permanent injuries, including when they occurred while carrying out assigned duties. These are some of the issues I intend to touch on in this presentation before concluding with a few recommendations. But before I do that, with the kind indulgence of Justice Kanyip, let me first highlight the international and domestic instruments on labor justice, as well as the evolution of this specialized labor court and its challenges. International instruments. The concept of labor justice and public interest are interwoven. Any initiative that engenders fair treatment in the workplace impacts positively on societal well-being. Indeed, the United Nations has on many occasions highlighted the importance of access to justice, which essentially means the right to have one's cause heard before an impartial arbiter. The international reference point for the concept of labor justice, as we are all aware, is the International Labour Organization, which in several instruments enshrines the right of workers to access justice without encumbrance. This includes access to courts and other forms of dispute resolution mechanisms in pursuit of effective remedy. In a tripartite declaration of principles concerning multinational enterprises and social policy, the ILO recently stipulated that member states provide workers access to a remedy based on respect for human rights, as well as on the rule of law and accountable institutions. Meanwhile, the parameters in any given jurisdiction to measure labor justice include fair wages, which indicates that workers are to be compensated by their employers in a manner commensurate with their output. Safe working conditions that guarantee protection from foreseeable danger and defense of their inalienable right to organize protests and negotiate collectively. There are, of course, several others, including not being discriminated against on the basis of religion, race, gender, age, and so on. If these parameters encompass the principles and practices that ensure fair treatment and protection of workers in their employment context, it goes without saying that the aim of labor justice is to address power imbalances between employers and employees, between employers and workers, and to promote the dignity of labor. Some of the international statutes meant to protect workers to which Nigeria is a signatory include freedom of association and protection of the right to organize convention. 2, right to organize and collective bargaining convention. 3, abolition of forced labor convention. 4, worst forms of child labor convention. 5, equal remuneration convention. 6, discrimination, employment and occupation convention. 7, maternity protection convention. 8, occupational safety and health convention. 9, violence and harassment convention. And there are several others. The overriding objective of these instruments is to promote fair wages, decent work, equitable labor rights, and social protection. Domestic legislations and the industrial court. In Nigeria, legislation relating to labor justice include the Constitution of the Federal Republic of Nigeria 1999 as amended, HIV and AIDS Anti-Discrimination Act 2014, National Insurance Authority Act 2022, Pension Reform Act 2014, Trade Dispute Act Chapter T8, Law of the Federation 2004, Trade Unions Act Chapter T14, Law of the Federation of Nigeria 2004, as amended by the Trade Union Amendment Act 2005, National Minimum Wage Amendment Act 2019, National Industrial Act 2006, Factories Act Chapter F1, Law of the Federation 2004, Against Persons with Disability Provision Act 2018, and a host of others. However, despite the plethora of legislation and the fact that Nigeria is a signatory to numerous conventions that should guarantee access to justice for workers, the reality is quite different. This can be gleaned from the way of labor justice are resolved in Nigeria, not necessarily to the satisfaction of workers. These include freedom from discrimination, ability to engage in collective bargaining, modalities for addressing the power imbalances between employers and workers, mechanisms for resolving disputes and protection against unfair dismissal, among others. This then brings me to the issue of specialized labor court, which the National Industrial Court of Nigeria represents. The evolution of industrial courts can be traced to 1806 in France, 1869 in Germany, and 1919 in the United Kingdom. But it was not until 1976 that authorities in our country signed on to the idea with the National Industrial Court of Nigeria, established to address labor justice in all its ramifications. The court became functional only in 1978. In the early years, the NICN faced several challenges that affected its effectiveness and efficiency. But even when operational, the court provided no reprieve for aggrieved workers for decades, as its judgments were unenforceable due to the lack of laws and procedures required of a superior court of record. The problem started with the Supreme Court decision in the case between the National Union of Electricity Employers and Bureau of Public Enterprises. The apex court held that despite the provisions of Decree 47, the National Industrial Court of Nigeria had neither exclusive nor coordinate jurisdiction with the state high courts. That judgment rendered the fact that the court was powerless for about 28 years of its operation was acknowledged in 2003 by no other than the president of this court, Justice Adejuma, in a very scathing remark. This was the way Justice Adejuma put it. The NICN remained practically moribund. I'm quoting him. The court sat only in Lagos for those years. It was clearly unknown, and its decisions and pronouncements hardly respected. End of quote. The Constitutional Amendment of 2011, assented to by President Goodluck Jonathan, changed the narrative by altering sections 6 and 254 of the Nigerian Constitution and including the National Industrial Court of Nigeria as a superior court of record with coordinate jurisdiction with high courts. The amendment also expanded the jurisdiction of the court to handle human rights cases emanating from the workplace. The court is also saddled with jurisdiction to resolve disputes between the Nigerian Labour Congress, Trade Union Congress, and government. Some challenges of the court. The NICN may have been envisioned as a specialized superior court of record with the aim of having its decisions everywhere in Nigeria. But this vision, in my view, is not yet achieved. Despite what my lordship said about the court having its branches in all the 36 states. That's not what I found. From its website, the NICN currently has 28 divisions outside the Abuja division. These divisions include Lagos, Kano, Enugu, Ibadan, Akure, Jos, Abakaliki, Adamawa, Ado-Ekiti, Anambra, Bauchi, Bayelsa, Benin, Benue, Borno, Cross River, Delta, Gombe, Kaduna, Lokoja, Minna, Owerri, Port Harcourt. This means that 8 states are left without a division of the NICN. Regrettably, that includes my state, Kwara, where the president of the court is no more than a registry located at 30A of a road in Ilorin. Besides, this lack of national spread raises the issue of awareness and accessibility. Many workers, especially those in remote areas, may not be aware of the NICN or may find it difficult to access the court due to geographical or financial constraints. This limits the court's ability to serve to serve all segments of the population effectively. There is another issue that relates to a crisis of mission, though not of its own making. In creating the NICN in the mid-70s, the military government at the period envisioned sustainable rapid industrialization of Nigeria, which they reasonably believed would make industrial disputes inevitable. For instance, between 1975 and 1985, Nigeria experienced significant industrial growth driven by the oil boom and government-led initiatives aimed at diversifying the economy. The period saw the establishment and expansion of various manufacturing companies across different sectors, including food and beverage, textiles, cement, pharmaceuticals, and more. Unfortunately, that sector is now almost comatose, with dire implications for the national economy. The number of judges in the NICN is about 33 as of 2023. This number is insufficient to handle the increasing caseload efficiently. The shortage contributes to a backlog and delays in adjudicating cases. When you add weak legal enforcement in the country into the mix, it is little surprise that many workers are without adequate protection, thus complicating the quest for labor justice. Distinguished ladies and gentlemen, I began from the premise that the NICN has done quite a bit to advance labor jurisprudence in Nigeria based on my rudimentary research. But as attested to by Justice Adejuma, the work of the court is not known to most Nigerians. Even lawyers are not particularly conversant with it, according to some legal experts. In his book, Rocheba's Labor Law Manual, with international conventions of occupational health and safety, Enobong Ete, who has edited several Nigerian labor reports and several other publications in the law sector, alluded to this. I quote him, "A good number of the lawyers that appear before the court, that's the NICN, do not appreciate the law and practice of the court, and consequently, they carry on as if what obtains in the regular courts necessarily obtains in the NICN. This is far from being so, as the NICN is a specialized court, permitted to regulate its procedures and proceedings as it thinks fit, and is not bound by any rules of evidence, although it may inform itself on any matter in such manner as it thinks just." End of quote. However, the biggest challenge to labor justice has come from the regular courts. Between 2010 and 2024, the NICN has had a number of its decisions overturned, particularly by the Court of Appeal and the Supreme Court. These reversals often stem from jurisdictional challenges, misinterpretation of labor laws, and procedural issues. I will highlight three of such notable cases and what they mean for labor justice in Nigeria. The first is the case between Sky Bank PLC, now Polaris Bank, and Victor Iwu. The NICN had ruled in favor of the claimant regarding wrongful termination of appointment, but the Supreme Court overturned the NICN decision and clarified that the Court of Appeal has the jurisdiction to hear all civil matters from the NICN, not just those related to fundamental rights. The Apex Court held that decisions of the NICN as trial court are not final. Considering that there were already two conflicting judgments of the Court of Appeal regarding appealability of the NICN on the issue under reference, this ruling overturned the prevailing belief that decisions of the court were final except in cases involving human rights or criminal matters, thus opening the door for more NICN decisions to be appealed. There are implications for this decision. I know that this may not sound well to lawyers, but I am of the view that the NICN should have both original jurisdiction and final say in some issues pertaining to workers, especially those related to compensation for injury or disease and wrongful dismissal. Allowing all cases instead of the NICN to be subject to appeal may not bode well in a country like ours, where there is a power imbalance between workers and employers. While it is considered that the right of appeal may encourage NICN judges to be more careful about the decisions in cases before them, some unscrupulous employers could use the right of appeal as a punitive measure or a delay tactic. The second case is that between Chevron Nigeria Limited and Mr. Titus Oyegun. While the NICN ruled in favor of the employee in a wrongful termination claim, the Court of Appeal overturned the decision, arguing that the NICN overstepped its jurisdiction by addressing certain contractual matters that should have been handled by the High Court. I am of the opinion, I'm not a lawyer, this is a layman opinion, so you can discount it, that the decision of the Court of Appeal overturning the decision of the NICN should be tested at the Supreme Court. I do not believe it is in the interest of labor justice to exclude contractual matters from the jurisdiction of the NICN. In the third case between Arik Air Limited and engineer Gabriel Ibinigi, the NICN had ordered the reinstatement of the claimant and awarded compensation. The Court of Appeal overturned the decision, finding that the NICN had exceeded its jurisdiction by ordering reinstatement. The Court of Appeal's decision was based on the time-allowed labor principle that you cannot force a willing employee on an unwilling employer. I understand the point the appellate court is trying to make, but I still do not believe the ruling will serve the end of labor justice. In such circumstance, I would prefer punitive damages and compensation for aggrieved workers as a deterrent to arbitrariness on the part of employers. The next point I want to make may sound a little bit heavy, but there's a perception among some stakeholders that the judges of the NICN tend to be biased, especially in favor of the government. That is understandable, since the jurisdiction conferred on the NICN dictates that a good percentage of its cases will involve governments as employer of labor. It is therefore my considered view that a labor court considered biased may be unhelpful in obtaining foreign investment, driving aggressive industrialization, and achieving sustainable growth. The independence of the NICN is crucial to our national prosperity, although I must state here that the allegation of being pro-government cannot be sustained by any credible evidence. When the federal government secured an injunction restraining the NLC from proceeding with its proposed nationwide strike last year, the Congress accused the court of, and I quote, continuous organization of the instrument of ex parte injunction in favor of government, end of quote. According to the NLC president, Joe Ajero, and I quote him again, that is against the interest of Nigerian workers. However, it should be noted that in several instances, government also ruled the existence of the court. I remember the former governor of Kaduna State, and his lordship, the president of the court, has already given his right of reply. I remember the former governor of Kaduna State, Madam Nasir El-Rufai, said that one of the biggest mistakes Nigeria made was to establish the NICN, citing instances when judgments were entered against government in favor of workers. So if neither government nor the NLC appear comfortable with the NIC, then the court must be doing something right. However, while the perception of being pro-government may be baseless, it can undermine public confidence in the court's impartiality and fairness. Bane of exclusive jurisdiction. As the ILO has successfully put it in their publication, Overview of Procedure for Access to Labor Justice in Judicial Dispute Resolution Institutions, access to labor justice should not only be viewed from the perspective of labor courts and the right to have a claim examined by an impartial judge. It should also encompass access to fair procedural regulation, which enables real conditions of equality before recurring to the judiciary. The emerging regime in labor justice globally is ensuring the effective labor dispute prevention and resolution in law and practice. That's why I must commend the establishment of the Alternative Dispute Resolution Center of the NICN to resolve certain labor-related disputes using the process of mediation and or conciliation. The notion of access to labor justice, according to ILO, and I quote, encompasses judicial and non-judicial mechanisms and institutions dealing with the prevention and resolution of individual and collective labor disputes. The point that I'm trying to make is that an effective labor justice system accommodates, not excludes, other active structural players. This approach may be touchy considering the exclusive jurisdiction of the NICN as guaranteed by the Industrial Act and the Constitution. Exclusive jurisdiction doesn't, in my view, enhance access to justice for workers. For instance, the history of the labor court in England shows how the major labor unions refusal to appear before it ultimately led to the labor court ceding the majority of its powers to administrative tribunals. The informal sector. I find it disturbing that in conversations about labor justice in Nigeria, there is hardly any thought given to the informal sector. Yet, as of the first quarter of 2023, according to the National Bureau of Statistics, according to a survey by the National Bureau of Statistics, 92.6% of workers in Nigeria were in informal employment. If we exclude agriculture from this sector, going by the survey, we still have 89.4% of our people in informal employment. How can we exclude such a huge percentage of workers from access to justice and social protection and imagine we can develop our society? Take farmers, for instance. By reason of their vocation, they are both employers and employees who feed the nation, but are classified within the informal sector of the economy. Their incapacitation by reason of insecurity and natural disaster has resulted in nationwide shortages of foodstuffs, high cost of food crops, and hunger in the land, impacting all Nigerians. Yet they are excluded from any form of labor justice or social protection. What the foregoing suggests is that in Nigeria today, labor justice is designed more for the formal sector. We need to redress this anomaly by the instrumentality of law and policies. Can there be a law mandating that at least 75% of labor justice standards applicable to the formal sector also be made applicable to the informal sector? With that, we can address issues like unwritten contract agreements regarding wages, hours of work, and other indices of labor justice enjoyed by the formal sector. At present, there is no such law. These are some of the issues that should concern the National Assembly, whose members seem obsessed with where and how Mr. Bobrisky was sleeping when serving his jail term. I am aware of the principles of the common law of contract that make some oral contractual agreements enforceable. So, may I ask, will this court or any tribunal indicate on the hypothetical case of an office clerk who refuses to pay him the peanuts he orally agreed to pay and then lays off after working for 13 months? Will our justice tribunal or court not be technically rigid by asking for a document evidencing the labor agreement? I want to believe Nigerian courts are already moving away from technical verdicts to substantial justice, elevating some above form of procedure. But we are quite slow about advancing it further and institutionalizing it in promotion of the public good, especially for the most vulnerable society. I now speak to an issue that Mr. Kuti pointed out earlier: proliferation of court injunctions. Before I take my seat, let me also make an important point about the justice administration in Nigeria. It is important because the extent of justice available to workers in any given society is a function of the extent of rule of law available in that society. It is therefore doubtful that citizens as workers can expect a higher degree of labor justice than what is available within the ambit of rule of law in Nigeria. In her speech at the special session of the Supreme Court commemorating its legal year and the induction of the latest set of senior advocates of Nigeria on Monday, 30 September 2024, the Chief Justice of Nigeria, Justice Kudrat Akekereekun, emphasized that obedience to court orders will, under our watch, be, I quote, non-negotiable. And that, and I quote again, no individual or institution, irrespective of their standing, will be permitted to treat the judgment of the court with levity or disregard. This indeed is as it should be in a society governed by rule of law. But rule of law is not the same as rule of judges. According to worldjusticeproject.org, the rule of law, and I'm quoting, the rule of law is a durable system of laws, institutions, norms, and community commitment that delivers 4 universal principles. 1, accountability. 2, just law. 3, open government. And 4, accessible and impartial justice. In contrast, rule of judgment denotes impunity towards the law by the very persons who ordinarily are invested in the functions and responsibilities of in which a judge places himself or herself above the law, or makes himself or herself the law rather than servant of the law or shepherd of the rule of law. Regrettably, the loud and overpowering noise of the latter is becoming definitive of Nigeria's judiciary in the perception of most people. Nothing gives better expression to that than the statement, "Go by conscious wrongdoers," often followed by "go on appeal" by their hand-in-glove judges. Aside the indiscipline of conflicting judgments, there is also the disgraceful issue of courts of coordinate jurisdiction nullifying one another since forum shopping has been institutionalized in Nigeria. In recent days, we have seen how the judiciary has been dragged into the power struggle between the godfather and his godson in Rivers State. If there is anything to take from what transpired before last Saturday's local government election in that state, it is the willingness on the part of an alarmingly increasing number of judicial personnel to accept and play the role of hitmen for influential political actors as against serving the interests of the country and the public good. That should also be of serious concern to Justice Kekere. I still cannot fathom how any self-respecting judge will grant an injunction refraining the police from performing its primary responsibility of restoring law and order during an election process. Unfortunately, it is such contrived court orders that the police are ever eager to obey, most often against the public interest, as we can see from the Rivers State. Meanwhile, at the rate some of our judges are going, they will start granting injunctions to spouses from performing matrimonial in the other room. How the prominent are openly describing judgments emanating from our courts as scandalous. It is incumbent on the National Judicial Commission to step in and deal with blatant deviant behavior among members. Conclusion and recommendations. To enthrone labor justice in Nigeria, there is need for effective enforcement of labor laws. This can only be achieved by simple and affordable access to the justice system and greater advocacy to protect most vulnerable of workers. But it's important to note also that labor laws in Nigeria are complex and with outdated provisions that make their interpretation and application challenging. This complexity has often led to unpredictable judgments and uncertainty in labor relations and justice. There is therefore an urgent need to align these laws with current realities and international labor standards. As I take my seat, let me briefly speak to the issue of compensation for injury or disease contracted at the workplace. Based on the duty of care to which workers are owed by their employers, the Employee Compensation Act of 2010 provides comprehensive compensation to those who sustain injury from accidents at the workplace. Apart from lack of awareness, the process is cumbersome and the compensation inadequate. As laudable as the law is, administrative hurdles and complexities in navigating the compensation process are barriers to implementation. There is a brilliant description of the Act by Mr. Ajibola Olaosebikan in one of the books I found at the library. And he wrote, despite the existence of robust legal frameworks, several challenges persist in the realm of employee compensation in Nigeria. Enforcement of labor laws can be inconsistent, especially in smaller enterprises or informal sectors where oversight is limited. This inconsistency sometimes leads to exploitation and unfair practices, such as inadequate wages or denial of benefits. Many countries have devised creative ways by which workers in the informal sector can access justice, especially when in distress, and there's no reason why we should not learn from them. In Canada, for instance, they have the Workplace Safety and Insurance Board, an independent trust agency operating under the Ministry of Labor, for small businesses that employ staff like nannies, babysitters, gardeners, bar attendants, and so on. Regulated by the Workplace Safety and Insurance Act, it is a collective liability insurance to which employers subscribe. It provides compensation to employees in the event of a workplace accident. Finally, we must understand that public interest is served when workers are not only fairly treated, but also economically empowered. But in a society where there is weak enforcement of labor laws to protect workers, it is easy for employers to evade legal responsibilities. That's why, and now, most of the banks and oil sector companies now deploy graduates as casuals who are paid peanuts and deprived of opportunity to become mainstream workers. This is an issue that should be addressed by relevant stakeholders. What government at all levels in Nigeria must understand is that a system that ensures labor justice also fosters cohesion, as addressing grievances in the workplace can prevent social unrest and promote harmony. Prioritizing labor justice, therefore, is a public interest imperative. To the extent that public interest is tied to ensuring a humane interpretation of socio-economic rights, relevant authorities in Nigeria must ensure that workers' rights are protected, fair wages are paid, and safe working conditions provided. All of these are geared towards balancing the rights of workers with the economic and social well-being of society as a whole. Thank you very much for listening, and good morning.
Beautiful. Wow. Again, a round of applause for Mr. Olusegun Adeniyi. That was a rousing one. We thank you, sir, for that thought-provoking, well-researched, and well-delivered address or lecture. And I won't pretend to summarize all that you've said. I will just quickly run through. You've taken time to take us through the rich tapestry of the court's beginning, gone through the historical trajectory of how the court started up to the point where the court is today, identify shortfalls that may hinder effective labor justice adjudication. For example, you made reference to not having presence in all the 36 states of the Federation, and that as of 2023, just 33 judges sit over the labor adjudication in Nigeria. Atypical of his writing, he also found time to bring out the humorous parts. There were anecdotes, beautifully used, and somewhere and got us laughing. I mean, I was wondering what Mr. Bobrisky had to do with labor justice. But of course, Mr. Denny found a way to also make a case for Mr. Bobrisky at the industrial court. He's propounded strong personal opinions and thought-provoking also. For example, how or why he thinks that the court should have a final say in certain aspects of labor matters. Compensatory damages, the quantum should effectively meet to deter arbitrariness in the world of work. I mean, arbitrariness in the determining labor relations. He's also gone ahead to draw a beautiful, he's tried to make some beautiful remark in relation to how there can be shades of opinion depending on who is getting judgment before the court. He's gone on to tell us that, look, the perception of even the government, as represented by Malam El Nasser's unguarded statement some time ago, can be that, look, the court has no business in Nigeria, and has also tried to go on to bring the shade of opinion from even labor in itself. And whilst he was saying that, I think he said that shortly before the president of the NLC, Comrade Joe Ajaero, walked in. You're welcome, sir. And he's gone on to also make some recommendations in the conclusion. Again, Mr. Adeni, we thank you, and then please a round of applause again for him. Whilst Mr. Denny was delivering the lecture, we had Comrade Ajaero coming. We're glad to have you with us, sir. We also have with us Professor Ademola Pokuola from the Faculty of Law, Obafemi Awolowo University. I'm delighted, sir, I am delighted personally to have you here. He was my lecturer at the university many years ago. Good to see you again, sir. We also have with us Leonard Silk Ekanem. Ekanem SN, thank you for joining us. And Comrade E.A. Williams, representing the Trade Union Congress President. Comrade Williams, good to have you. All right, without much ado, we still have a couple of things lined up for today. Let me at this junction quickly move on to the next item on the program of events, and that is the goodwill messages. Would invite the Minister of Labor and Employment or the representative to please come to the podium to render a goodwill message for the court in the new legal year. The Minister of Labor or the representative, if you have anybody here. If there is none, we go on to the President of the National Labour Congress, Comrade Ajaero. Thank you, sir. There you go. God bless you.
Solidarity. I don't know whether my people are here.
We are here now.
Solidarity. Let me stand on the existing protocol and apologize for coming in late and go straight to the goodwill message, since we are not here for negotiation. However, I won't thank the president of the court, for extending the invitation always to us, even when we disagree on some key issues. Thank you very much. I bring you the compliments of the Nigerian Labour justice virtually every other day. It is for this reason we are specifically privileged to be part of the activities marking this year's legal year. We will not hair split by recourse to definitions, as we all know that legal year is a calendar period during which judges sit in court to preside over cases or dispense justice. There is nothing like justice issues. Celebration of the legal year presents an opportunity to x-ray some of the aspects of the National Industrial Court. Section 7 of the NICN Act confers exclusive jurisdiction to the court on matters of employment. In spite of the prevailing challenges, the National Industrial Court has discharged statutory duties with candor. It has been bold, courageous, and inspiring in its pronouncements. However, given the nature of the cases that come before the court, undue reliance on technicalities does tend to have delay effects. Given the nature of the issues, delay constitutes denial in some instances. This, our appeal would be less technicalities, even as the blame for delays, in all fairness, should be shared. Obedience to the decisions of the court, especially by employers, has not been comprehensive enough. We have no record to suggest that such manifest disobedience attracts sanctions. In light of this, it is our desire and wish for the court to ensure that its decisions are not only enforceable, but are enforced. The mileage covered by the NICN often suffers reversal at the Court of Appeal, largely due to the imposition of common law principles on purely contract employment issues, with consequential effects on scope and dimensions of compensation. In order to minimize these setbacks, we would propose that a special division of the Court of Appeal be created and dedicated to cases from NICN and staffed with judges sufficiently versed in the issues of delay, but the issues of substance. Finally, injunctions, with all due respect, even as it's within the right of the court to grant injunctions, motion ex parte, we find ourselves at the receiving end. As the court exercises this power, even as we know that the court ought to exercise this very power with utmost due diligence and sparingly, so that it does not lead to miscarriage of justice. Specifically, in the matter of our notices to government to protest or strike against its policy of fuel subsidy removal, we are at the receiving end. Indeed, we are where we are today in terms of economic challenges arising from the increases in the pump price of petroleum products because of these injunctions. Invariably or inevitably, we are compelled to ask, can we ever win against government in the court on matters connected to social economics? Wouldn't it constitute an irreparable and irreversible injustice if a competent court of law is hamstrung from giving justice to deserving parties? Finally, the first industrial revolution is IT-driven with artificial intelligence, taking the lead in our industrial space, although we are not yet at par with advanced economies on this. How prepared is the NICN to resolve employment issues arising from ascendancy of AI at workplaces? Conclusion: we are all in an evolving process and can only get better with time. Thank you for listening, and once again, do accept our congratulations for successfully organizing this outing. Thank you very much.
Thank you, Comrade Ajero. I will go on to the Director General of the Nigerian Employers Consultative Association, NECA, Mr. Adewale Smatu Yerinde, or his representative. If there is no one from NECA, the representative of the President of the Trade Union Congress, TUC. Thank you. Representing Mr. Festus Osifo.
Solidarity! Solidarity is forever. The Honorable President of the National Industrial Court of Nigeria, Honorable Justice Kanyip, today we are here to felicitate with you today, and it's not the other way around. We had a very good discussion and interaction during the May Day. Thank you for always being with us. Well, today I'm here representing the President of the Trade Union Congress of Nigeria, Comrade Engineer Festus Osifo, who is unavoidably absent here today. My name is Comrade Iye William Adegbe. I have his message here, which I will deliver, since he's not able to be here live. It is a good thing that we have gathered here today to mark the beginning of the new legal year of the National Industrial Court of Nigeria, which to us is a significant milestone in the nation's industrial relations calendar. The Congress, as an umbrella organization of Nigerian workers, acknowledges the vital role of the National Industrial Court plays in promoting industrial peace, resolving disputes, and interpreting labor laws. Your dedication to upholding justice and fairness has been instrumental in shaping Nigeria's industrial relations landscape. As we reflect on the past legal years, we commend the court's effort in the following areas: promote dispute resolutions, reducing industrial conflicts, landmark judgments promoting workers' rights and social justice, and enhance court administration and processes. Looking forward, we reaffirm our commitment to collaborating with the National Industrial Court to enhance the interests of Nigerian workers. Our key areas of focus include promoting decent work, encouraging fair labor practices, safe working conditions, and equal opportunities. Social dialogue, fostering collaboration between workers, employers, and government. Workers' rights advocating for policies that protect workers' welfare. To achieve these goals, therefore, we propose the following. strengthening partnership between the Honorable Court's workers and employers organizations, regular stakeholders engagement to address emerging industrial issues, capacity building program for justice, lawyers, and union officials. To achieve the above, we pledge to support the court's initiative that promotes industrial harmony, advocates for policies that enhance workers' welfare and social protection, and foster constructive dialogue with employers and government. Finally, as we embark on this legal year, we express gratitude for the Honorable Court's unwavering commitment to justice. We look forward to strengthening partnership and continuous or conscious efforts that promotes industrial growth and social progress. I thank you for listening.
Thank you, sir. That was a firm chant of solidarity. We call on Madam Ahmed Gobe, who is the president of the Chartered Institute of Personnel Management. Sir, good to have you here.
The chairman of this occasion, let me crave your indulgence to stand on the already established protocol. I'd like to start by thanking the president of the National Industrial Court for inviting us to this public lecture, of course, to celebrate the new legal year. We owe the court and its president a debt of gratitude because our paths, of course, did not just cross recently. I have had a personal relationship with the president since my days as a law student in the Faculty of Law in the Ahmadu Bello University's area. But perhaps the most recent of His Lordship's graciousness was the fact that when I was elected president of the Chartered Institute of Personnel Management, my Lord sent Justice Sanda Audu Yelwa of the Lagos Division of the Court to come swear me in on the 31st of July during my investiture. My Lord, the Institute and myself are very grateful for this. Personally, my history again with the court also goes back to my days when I used to work for a company called Crystal Hope. My Lord Justice Adejuma will not remember me, but I was at the time the Deputy Managing Director of Crystal Hope, and we were responsible for doing all the doors and windows of this beautiful edifice. My Lord, we are grateful for that patronage, and thank you very much, sir. To our goodwill message, on behalf of the Chartered Institute of Personnel Management of Nigeria, we extend our warmest congratulations to the National Industrial Court as we embark on the 2024-2025 legal year. This annual milestone is not just a reflection of the court's dedication to upholding the rule of law in Nigeria, but also signifies a renewed commitment to justice and equity in our labor and industrial relations practice. The role of the National Industrial Court is crucial in fostering a harmonious work environment and ensuring that the rights of all stakeholders in the labor market are protected. The efforts put into adjudicating complex industrial disputes and providing a platform for fair resolution greatly contribute to the stability and growth of our nation's workforce. As we look forward to this new legal year, we encourage all to continue to champion justice with integrity and with compassion. May your decisions continue to inspire confidence in the legal framework that governs our labor relations, and may they promote fairness and equity for all. We appreciate the hard work and the dedication of each member of the court, and we look forward to our continued collaboration in enhancing human resource practices and promoting industrial harmony. Let me also say that yesterday I had the privilege of speaking on Channels Television, and one of the questions I was asked by Ayotunde Balogun was around casualization of labor. Our position, of course, remains the same position that the NLC continues to canvass, and which we also had Mr. Olusegun Adeniyi speak about here. We frown at casualization, and we will continue to speak against it as a professional institute. The second thing and the second question I was asked was around, the Nigerian Labour Act. And my response, of course, was that, well, although the National Industrial Court, through its judgments, continues, of course, to reshape employer-employee relationships by the judgments that are delivered by the court, and of course also continues to help reshape our industrial relations landscape, there is a need for an urgent review of our 20-year-old Labour Act, which we believe, for all intent and purposes, especially in the year, now that we're in the AI era, are obsolete. We, as a professional human resource institute, will collaborate with the labor centers, will collaborate with employers associations, we'll also collaborate with the National Industrial Court to ensure that whatever needs to be done to get the Labour Act reviewed in the interest of Nigeria's workforce is done. We thank your Lordship again for inviting us to the opening of the new legal year, and we look forward to further collaboration with the NICN. Thank you very much, sir.
Thank you, sir. I wonder if there's the chairman of the Nigerian Bar Association section on business law, Mrs. Ozofu Latunde Ogemudia, in the hall. All right, if she's not here, we'll go to Mr. Ugona Ogbuagu, who is the secretary of the MBA section on business law, Employment and Industrial Relations Committee, to come give a goodwill message.
Thank you. Good afternoon, everyone. My lords and our honored guests present, may I humbly pray to stand on all existing protocols so as to save time. My name is Ugonna Ogbuagu, and I am the secretary of the Employment, Labor and Industrial Relations Committee of the MBASBL, the Nigerian Bar Association section on business law. And with the permission of the chairman of the committee, Mr. Folabi Kuti, SAN, I'm here to deliver a goodwill message to the National Industrial Court on account of the opening of the 2024 and 2025 legal year. On behalf of the MBASBL, Employment, Labor and Industrial Relations Committee, I extend our heartfelt congratulations to my lords of the National Industrial Court of Nigeria on the commencement of the 2024-2025 legal year. We take this opportunity to commend the court for fostering an environment where stakeholders, litigants, employers, unions, council, and others can engage constructively ahead of the new legal year. The court's commitment to receiving feedback from stakeholders is truly progressive and deserving of recognition. Your lordships play a pivotal role in upholding labor justice across Nigeria, especially in today's rapidly evolving work environment. The rise of the gig economy, remote work, equality initiatives, and the digital revolution have transformed employment relationships and challenged traditional legal frameworks. We are grateful for your Lordship's expertise and fairness in navigating these complex issues. As we embark on the new legal year, we acknowledge the challenges ahead, but we also see opportunities to reaffirm the court's commitment to fairness, crafting decisions that shape a more just and inclusive society. We urge your Lordships to continue approaching these evolving legal issues with the courage, wisdom, and integrity that have long been hallmarks of this honorable court. As a committee, we remain committed to collaborating with the bench, to strengthen labor jurisprudence in Nigeria. And we deeply appreciate your Lordship's unwavering dedication to labor justice and look forward to more groundbreaking strides and decisions in the year ahead. Your Lordships, please.
Thank you very much, Mr. Ogona. This effectively brings us to the end of the goodwill messages. The flow of the program is that we go straight into the Bar and Bench Forum next. And I mean, that's the part of the program that I said earlier on that for once, we lawyers will have an opportunity of posing questions to my lords without being cited for contempt. So, and this is the beautiful part when, even if it's just once in a year, we get to ask my lords questions. And to handle that, I would like to invite on the stage Mr. Jamiu Akolade, who is a trustee of the Employment and Labor Lawyers Association of Nigeria. Mr. Jamiu Akolade? Yes. Yes, okay. All right, sir. Mr. Jamiu Akolade, please come up. And then Ms. Mary Kemeze, who is the Vice Chairman of the section of the MBA Section on Business Law, Employment and Industrial Relations Committee. My name is listed on the program for the question and answer, but I'd rather dodge the bullet and let them handle it. Thank you very much, yes, sir. Where's Mary? Where's Mary? Okay.
So we start that? Oh, you printed them out. It's not my style. Start. Is it morning, afternoon?
Good afternoon, ladies and gentlemen. Hey, a lot to yes. Distinguished members of the bar, we stand on all existing protocols. It's a pleasure to be here with you this afternoon, to be moderating this session with my colleague Jamiu. Okay. It's a pleasure to be with you this afternoon to moderate this session with my colleague Jamiu. So what we had done was ask for questions from various members, the various branches in the Federation, regarding what they would like to see in terms of improvements in the administration of justice. And we thought that this, and since His Lordship has graciously granted us the opportunity, we'll have a couple of questions. About 18, we hope you'll bear with us. Yes. I don't know where I want to start.
Thank you. Mr. Adeniyi is somebody I respect. I read his column every week. To start with, I have to apologize that I'm so informally dressed for this occasion. I had to come straight from the airport because I was interested in this. I love the intellectual depth of the National Industrial Court, so I'm always interested in these things. I didn't have an opportunity to get to my base in Kaduna to change and dress properly. My name is Namonso Ekanem, Senior Advocate of Nigeria. I practice out of Kaduna. The speaker, Mr. Segun Adeniyi, made this comment about the judgment of Justice Leaf recently on the Rivers State issue. You know, there's this judicial bashing by the Nigerian public, and sometimes by even the bar. People make comments on judgments they've not even read. Mr. Adeniyi said, if I got him right, that judgment restrained the police from doing its duty. From my knowledge, I don't know whether he has read the judgment. I haven't read it, but from what I can decipher from that judgment, the Honorable Judge said, look, you've not done A, B, C. Having not done that, police, you should not aid that until they comply with this, that. You, police, don't aid. The judgment didn't say the police shouldn't do its duty or carry out its duties. And that is what is being brandished around, that the court restrained the police from performing its duties. That was not that judgment. That judgment was, since these people have not met criteria A, B, C, police don't aid them in doing this. So I think we need to correct that impression. And before bashing, I would like the speaker, Mr. Adeniyi, to try assess and get a certified copy of that judgment, read it, and be in a position, maybe in your column, to state the position as it is. I don't think the court restrained the police from doing its duty. Thank you very much.
Okay. Thank you very much, sir. So we'll go right into the questions. Whose hand is up? Okay. So maybe we'll take your question or comment after, please, so we can get started. We know that a number of people are here primarily for this Q&A, and we would like to take advantage of the fact that our judges are here. So I will come back to you after I've taken some of the questions, please. Thank you.
Very sorry, Leonard Silk, but we are running out of time. Thank you very much, Mary, and I also stand on existing protocols, but I must say good afternoon to my Lord. And okay, I need to get a second microphone. Do we have another microphone? The technical people. Okay, so my lords, honorable justices of the Industrial Court, we are very grateful that you've created time to have this session with us. So like Mary mentioned, we have quite a number of questions that cover that have broad coverage of the operations of the court, administrative issues, the jurisdiction of the court, international best practices, and basically themes regarding the emerging trends, future of work, questions that maybe the court has not dealt with yet, but that we expect the court may be dealing with very soon, and would like to get a glimpse of how the court may approach such issues. One of those issues that we've gotten from lawyers is with regards to the expansion of the definition of labor, essentially expanding the scope of the court jurisdiction. My Lord Honorable Justice Kanye recently delivered a judgment in Alpha Sin Nigeria Limited and Registered Trustees of Prince and Princess Estate Residents Association. That was a July 2023 decision. And in that decision, my Lord essentially expanded, in the view of most lawyers, what labor means by extending it not only to individual employment relationships, but also to contractual relationships that are for supply of labor or that employ labor. And practitioners are asking, is that a foreshadowing of what is to come in terms of that limb of Section 254 on labor and matters incidental or connected therewith? Lawyers are asking if this would not be a stretch. So would we say, for instance, issues of data protection in the workplace can conceivably be dealt with by the industrial court in times to come? So that is the question, and I'm not sure how my Lord would want to allocate these questions, or whether my Lord would want to take it himself. Yes.
Can I sit down?
Yes, sir.
Thank you. The case appears to be notorious. Yesterday, when the chairman of the body of benchers spoke on behalf of body of advocates, he alluded to that particular case. In particular, he expressed, should I say, joy that it elicited jurisprudential and intellectual issues which is being discussed. Whoever reads that judgment should understand the point made and where and arguments that were raised. The first argument was that there is no known decision that has defined within the context of jurisdiction the use of the words employment, labor. The argument being the drafters of the Constitution, in repeating the words employment and labor, must have meant something. I was referred to by counsel to the general definition of labor, which does not make distinctions between contracts of service and contracts for service. So if NIC has jurisdiction over labor, and the definition of labor, the ordinary definition of labor, encompasses both contracts of service and contracts for service, I was urged to accept that as the intendment of the drafters. That's one. The second point, we have jurisdiction over international labor standards, and ILO has never made the distinction that the standards applied only to one kind of labor. They apply both to contracts of service and to contracts for service. Thirdly, there is the Supreme Court decision of Shino Securities versus Afropac. The two cases involve companies. Shino Security is a company, Afropac is a company. But the question the Supreme Court had to answer was a contract for the supply of labor. And I'm sure you will agree with me that in ordinary definition, that is a contract for service. In a contract for supply of labor between these two companies, the Supreme Court held that it is a contract of service. Now, if you go to the Labor Act, as old as that act is, go to Section 91 and see how recruitment is defined. It is defined to include supply of services. So, if the Labor Act makes that definition, and don't forget, NIC also has jurisdiction over the Labor Act. If you were in my shoes, what conclusion will you come to? That jurisdiction now must be severed between contracts of service and contracts for service, when what the Constitution says is that NIC has jurisdiction over employment, labor, industrial relations, and a host of other items. We are a first instance court, no doubt. Some of these issues, no doubt, and I was very specific that I was convinced because of the Supreme Court decision of Shinopac and Shino Securities and Afropac. Now, whether the Supreme Court was right or wrong wasn't the issue. The question is that the Supreme Court held that the supply of contract or services is a contract of service. And what was the issue in this particular case? It was a dispute over the existence or otherwise of a management contract where a certain company was contracted to provide management services to an estate here in Abuja. How this decision is going to play out in future is something I can't tell you. It's something that must come on a case-by-case basis. But for now, I think I'm not even aware that an appeal has been made, but that ruling was first in respect of jurisdiction, and then there was a substantive decision in respect of the subject matter where the claimant was held not to have a case, because based on the interpretation of the management contract, his argument was that he was entitled to a renewal of the management contract. And the merit of the case held that he was not entitled to it in virtue of the wordings of the contract itself. I understand he's on appeal. I don't know on what of the issues, whether it is on jurisdiction or on the merit of the case and so on. But for us to be able to answer questions like this holistically, I want us to note some issues. One, the definition of labor does not make distinctions between contracts of service and contract for service. Two, international labor standards apply in the world of work, and the world of work is comprised of those who are in contracts of service and contracts for service. Thirdly, the Supreme Court says a contract for supply of service is a contract of service.
Thank you very much, my lord. So I think we'll take reactions to the answers maybe at the end of this session, because you know, we can spend the whole day on this very issue itself. So maybe we'll ask the next question.
So, in Alpha-Sin Nigeria Limited versus Registered Trustees of Prince and Princess Estate. Oh, this is the one? Sorry. We're going to 5, 7. Right. Since the Court of Appeal's decision in Sahara Energy Resources Limited and Mr. Olawumi Oyebola's, the NICN seems to have adopted an incremental approach to the award of damages for wrongful termination, jettisoning the age-long salary in lieu of notice. Recently, the Supreme Court in Skybank PLC and Adegu, though arising from a pre-third alteration decision, upheld an award of damages of 2 years' salary to an employee for wrongful termination, and held that the award of damages when an employer terminates an employment contract in violation of its terms cannot be limited to the employee's remuneration during the notice period specified in the agreement. Some cases arising from the NICN still award salary in lieu of notice as compensation for wrongful termination, even where it would seem the claimant is deserving of more. What can be done to stem this trend?
After the Skybank case, 10 days later, there was Dangote by the same Supreme Court, which went back to payment in lieu of notice as the measure of damages. I wrote on conflicting decisions at the last MBA conference. and I discussed the two cases, the two Supreme Court cases, where incidentally there were two justices of the Supreme Court who were in both cases, even when both cases appeared to hold or come to different conclusions. And my point was very specific. Both Skybank and Dangote had to do with causes of action that were pre-third alteration, which means whatever was decided may not necessarily work for purposes of the third alteration dispensation. But my viewpoint was that the Skybank decision accords more with a third alteration dispensation dispute than the Dangote. And why am I saying so? Why would I, as an employer, tell you your services are no longer needed, and I don't give you the 1 month's notice, and I tell you to go? Then you take me to court, and we spend the next 3, 4, 5, sometimes up to 20 years, only for a court of law to turn around and say the measure of damages is that money you should have paid 20 years ago. Is that equitable? We're all workers. Forget the fact that some of us are judges. We're all workers. Tell me whether that is equitable. The Ghanaians, years back, in fact, there's a Court of Appeal decision, Makonjola and British Airways, or the other way around, British Airways and Makonjola, that was decided, I think, in 1998 or so, where the Court of Appeal was very specific that it is inequitable to give as measure of damages 1 month or payment in lieu of salary. Because that by doing that, you are simply patting the employer on the back and telling him to continue to do that which he has done, which is to disobey the contract in the first place. The contract says give payment in lieu of notice. At the point of terminating or disengaging, you did not give. And now you are asking the person to go to court and then spend years and only to come back and say, no, the measure of damages is that payment in lieu of notice. So as far back as 98, Court of Appeal in Nigeria decided that that was inequitable. And it was following the position in Ghana, where the Ghanaian authorities, the judicial authorities, felt that it's, in fact, to use the language, they describe it as preposterous to expect that an employer who refused to keep to the terms of the contract should merely be told to now keep to the terms as a reward for not keeping to terms. So sometimes I make this point when I have opportunity to talk that people don't understand the context in which some of these things happen. Late Justice Ike of the Supreme Court, of the Court of Appeal, when I was in Lagos, there were a number of decisions he was part of that overruled me on this point. It was much later, in a private discussion, he said, Kanye, this thing that you people are doing, it is now we are beginning to see sense. He said, imagine an employer coming to us because they say he should pay damages of 2 million naira, wasting everybody's time because of 2 million naira. That was the point I think they were beginning to have a rethink. Even in Lagos Division, that no. We need to take a closer look at some of these things. I think it was the guest speaker or one of the speakers earlier who made mention about employers deliberately going and appeal in order to stall or punish employees. Once you don't understand this context, in fact, the UK Supreme Court, for instance, and luckily the case cited, Sahara, was noted by Justice Ogwaku, how it is sometimes useful to defer to judges who are neck deep in an area because they know the nuances, they know everything there is. I'll give you a simple example. There is a UK Supreme Court decision, and the question was, at what point in time can you say an employee received the notice of termination? Was it when the letter was written but not posted? Was it when it was posted but not received? Was it when it was dropped in the mailbox in front of the house of the employee? Or was it when the caretaker of the house came to that mailbox and took the mail and dropped it on the table in the house? Or was it when this employee came back from holiday, actually saw the envelope, opened it, and read it? To be able to decide that question, what the Supreme Court of the UK did was first to ask the question, how is the Employment Tribunal in the UK treating this issue? So it went ahead and reviewed over 10 cases decided on that question by the UK Employment Tribunal. And what the Supreme Court of the UK did was to come to the conclusion and say, we cannot disturb their findings. And don't forget, they have this other part of precedent that we hardly operate in Nigeria. You know, precedent says you are to obey courts' decisions that are up, down. But they also have the reverse, where the UK Supreme Court will tell you, we will not disturb established precedents by lower courts where no injustice has been caused. So long as people have arrange their affairs according to those established precedents. So, when they looked at the totality of this, within the context of the question that was brought, and what was the question? Any holding other than that, it was at the point the envelope was open and read, would have meant the poor woman will not get pension because she would not have met the statutory time limit needed for pension to accrue. The UK Supreme Court said, no. What the Employment Tribunal cases show was that termination is effective only at the point you open the letter and you read it. And that was the holding they did in allowing the woman to get pension. So sometimes these things are being done within the context of the problems that arise. But unfortunately, if you don't understand those contexts, and you apply strict rules. And what is a strict law? All of us read law of contract. We are told that a contract is completed as soon as acceptance is posted. Is that not the rule? You can't carry that kind of rule and apply in employment cases, because the injustice it will work is one that you can't rectify.
Thank you.
Thank you very much, my lord. And that's very progressive thinking, if I can say so myself. So this is one of those questions where it's futuristic, and it's about hours of work. You know, one of the things we've grappled with under our labor law jurisprudence is that we don't have legislation on hours of work. In my limited knowledge, I think we can only rely on the ILO conventions on hours of work and all of that. And what we've seen that do to workers especially is that even though their contracts may have 9 to 5, the employers are able to craft this omnibus line to say you may be required to work extra hours for the advancement of the business and all of that. And in these days, it's leading to a lot of overtime, which is usually not paid for, and mental health challenges for workers. And practitioners are asking that what is the court's view on the right to disconnect that is gaining traction all over the world? Do we limit ourselves to the contractual stipulation that, oh, we can require you to work anytime, you are bound to obey your employer's lawful orders? at any time to further the business? Or is the court willing to consider the effect of overwork? Is it something the court is looking at presently, the effect of overworking on the employees? And would it be willing, in the absence of legislation, to uphold a right to disconnect under Nigerian law?
First, you called it futuristic, which means you want to come to court. And if you come to court and we tell you an opinion now, all of us here, it means none of us will have the right or competence to hear the case again. If you want to sue as to hours of work, I will advise you come to court first. Then we can tell you what we will do when you come. The only thing I need to correct is I think the Labor Act is specific about 8 hours. The Labor Act is specific about 8 hours. I don't think we rely only on ILO. The Labor Act has provisions about hours of work. So if you check that, you would find the hours of work and the provisions relating to overtime. Short of this, let us not predict the outcome of a case that may come. You call it sub judice, right?
As a couple places. So we'll move on to the next one.
Actually, there are members of the public who want to, maybe if you allow them to also come in, as you ask, they ask, as you ask, so that people don't get tired and start going away.
Thank you very much. Thank you very much,
Where's
my
the
lords.
other mic?
Yes. My name is Bimbo Atilola. And my response, somebody came to give me. Oh, please.
Who did you ask to talk?
Somebody came to give to me, sir. I'm sorry.
No, I think it's the SAN.
I didn't know he has no authority to do so. He came and handed over the mic to me.
No problem. Thank you, my lord. My name is J.S. Okutepa. Mine is to first thank your lordships for this bar bench forum that we are in. And what I want to appeal to all of us here, because we have serious problems on our hands, we must discuss it frankly. Otherwise, we are likely to heal some wounds on an iron. And soon after we leave here, the ripple effect will be too much. First, let me thank Shegun. This is my first time of seeing you face to face. And I was not expecting anything less from you, because I think it was Otman Dafodio that says that conscience is an open wound. Only truth can heal it. So I stand with you 100% your presentation. Let me correct an impression. I've had a copy of the Federal High Court judgments. I've read it, and relief number 6 is a restraining order. I have the copy, you can look at it. And as lawyers, we have been told that you don't restrain performance of executive functions or administrative functions until it is wrongly done. Those are principles of law of considerable antiquity that no one can pretend not to know. That's number one point I want to make. So, that you are not a lawyer does not make you less knowledgeable about the facts. So I commend you for what you say, and I thank you that you said it. Some of us are saying it because Nigeria is ours to preserve. And as lawyers, we are told that we are social engineer. And so I thank you. Second point, I want to commend you for the issues you raise. Is about the desire and the request that as lawyers, we should keep quiet and be defending judgments of courts. I find it extremely difficult to defend a judgment that is not rooted in the purity of justice. And so we are entitled to criticizing it. Because if you don't, and I'm happy Professor Popola is here, part of the reasons in those days when you have judges inviting academicians and lawyers and other things is for us to look at how wrong they were and how it has been criticized, and references are made to well-informed articles. I think, my Lord, this bar forum should be extended beyond National Industrial Court. We are getting to a place now where we as lawyers, and I speak for myself, it's difficult for you to advance your clients on settled principles of law. And so when the rules and judgments of court have engaged themselves in chameleonistic decisions, it will be difficult for a lawyer to advise his clients. So today, we're all a danger species. The lawyer, the judges. I was in a place day before yesterday, and I described myself as senior advocate of Nigeria, and somebody said, Sansan. Yes. So, I think that while I know the pressure that your lordships are under as a result of what appears to be almost absence of independence in so many steps leading to, we must talk about it. Otherwise, when Nigeria collapses on the basis of decisions rendered by courts, all of us may not escape it. We're all students of history, of ABS. The freest and fair election in Nigeria was nullified on the basis of Association of Better Nigeria, orders said to have been given by a judicial officer. When politicians have no respect for due process and rule of law, they should not be preaching to us that they are obeying one set of order or the other. So my submission, therefore, to us, my Lord, is to thank you for provoking this talk. We should carry it from here, like you rightly said yesterday to us, that when we want to make proposal, we should take it to NJC. Let there be bar bench forum where all judges of Nigerian Superior Courts of Record, including that of the Supreme Court, will be in attendance. We'll look at ourselves. If I am found to be one of the lawyers that comes Nicodemously to meet them in the night, they should be bold enough to tell me that I have done so. But, my Lord, until we do so, and we are trying to placate and give baptismal name of right to wrong, the calamitous end may be too difficult for us to bear. And so, Shegun, I thank you. I wish I have opportunity to admit you to the bar. I would have done so, because you do not need to be a lawyer to read the contents of a judgment of a court. Final point, my Lord, is whether time has not come when we should go back to the old school of allowing political class to deal with themselves and leave the court alone. Because we were told before, prior 2006 or thereabout, that political disputes are not justiciable. And when you look at the Electoral Act, the jurisdictions of the courts of the Federal High Court, which have been taken away from the State High Court, is limited to issues of pre-elections. And the pre-elections section 285, subsection 14 of the Nigerian Constitution has defined what constitutes pre-election matter. And so, section 251 of the Federal High Court, of the Constitution, delimits the jurisdiction of Federal High Court. So we need to now take away our courts from political disputes. Otherwise, like my Lord late Justice Nikki Toby said, partialities are the attributes of politicians. Impartialities are the attributes of judicial officers. But today, it will be difficult for us to make a distinction between political partiality and judicial partiality, given some of the decisions that we have seen. So my view, therefore, my Lord, is that let us now begin to think of taking away our judicial officers from adjudicating on political matters, because that is where majorly the challenges we have are. I finally commend your lordships, and I said to one of my lords here yesterday that the way you treat us, National Industrial Court, as colleagues, we hardly get it from some other courts. Time has come when the demarcation of judicial emperors and legal slaves should be removed. Because we are first and foremost colleagues. When you come to a court and you are trying to assist the court in the cause of justice, say, Mr. Kuteba, sit down. I am asking you to sit down. This is my court. No. This is the court of law. We are all equal ministers. There are judicial intimidations of lawyers appearing in courts, in some other courts, not National Industrial Court. And we must be bold enough to say it. Lord, and I thank God that I trained under one of the best. And I'm happy the chairman of the occasion is here today. For 5 years, I hated him. He's here. My Lord Justice A.J. Mbieko, 5 years, I didn't like him. Why? Because he was trying to put me on the foot of how advocacy is conducted, how papers are prepared, until 5 years that the man himself invited me. He's here. And so I know the distinction between a judge who wants you to know and a distinction between a judge who wants to harass you out of the court. The latter is what we experience in some jurisdictions now, unlike Ecos Reformation, which I experienced when he was a judge of High Court. So, my Lord, all I am struggling to submit this morning is that this backbench forum is good. Let us look at ourselves face to face, and then begin to decide that we own this country, not those or its equivalent. We have our LLB, and we are the one to show them what to do. Let them not show us how to destroy Nigeria. Nigeria is being destroyed using the judicial system that is a defined qualification.
Thank you very much.
And we should not continue. Thank you, my Lord.
Thank you very much, sir. Thank you very much for your intervention. Okay, so before we proceed, we'll just recognize some eminent personalities that came in while the session was on. You Osule, SA Honorable Bencher, you're welcome, sir. Honorable Justice Ibrahim Salim of the Federal High Court. We are also pleased to have you here. Same as the chairman, MBA Gwagwalada branch, Mr. Owo Clever. You're all welcome. I think we should give Mr. Atilola the chance to ask his question now, since he was already on his feet. Mr. Atilola, we can make it quickly, in a minute or two.
My noble lords, I thank you for this opportunity to...
Your mic, sir.
My noble lords, I sincerely thank you for this opportunity. Now, mine is a response to the question earlier asked, which my lord has declined comment for official reasons. The starting point is that it is not everything written in contract of employment or employee handbook that the court will enforce. Labor courts do not operate to endorse whatever parties have agreed. And this point has been indeed endorsed several times by various NIC decisions, citing the popular court of law in India that says that courts of law, especially labor courts, do not operate to endorse whatever parties have agreed. So, and we have several decisions where this court has nullified provisions in the contract of employment, even when they are signed, including provisions in employee handbook. For instance, in Betty Ngbeyi versus Unity Bank, my Lord Honorable Justice B.B. Kanyib nullified a provision of the Unity Bank handbook that says if you resign while disciplinary process is ongoing, that the bank has the right to reject your resignation, notwithstanding the fact that that provisions of employee handbook is supposed to be binding, being a contract, the court nullified. We also have several decisions of this court where restrictive covenants that are considered unduly long or that are considered oppressive, even when employees sign them in their contract, even when they have worked under such conditions, we have seen cases, and too many to mention, where the NIC has struck them down. So on the question of working hours, like my Lord has noted, Labor Act has a provision on working hours, and we call relevant ILO provision or conventions on it. So beyond the Labor Act, the court may even have regard to relevant provisions of ILO conventions as evidence of international best practices. So even in the absence of a direct provision in the Nigerian Labor Act, the court can have recourse to relevant ILO conventions if it can be shown that they represent international best practice. And of course, there are several decisions where this court has endorsed ILO conventions as evidence of best practice. So finally, I have no doubt that if a contract of employment endorses unfairly or unduly too long working hours, even where the employees are signed it twice or 3 times, the court will still nullify it, recognizing the unequal bargaining powers between the employer and employee. When people talk of equal bargaining power in employment relationship, I always liken it to a tenancy agreement in Lagos, which is standard form contract, which is drawn by a party, by the dominant party, to which the weaker party, which in this case, in the employee, either takes and signs or leave it as it were. Thank you very much.
Thank you very much, Mr. Titola. So we go now again to our questions, and this is an administrative issue. Is the NICN considering making its judgment database more readily searchable by adding indexes or partnering to put it on existing law reporting platforms, or perhaps adopting AI to aid research in it?
We are open to improvements. If you have something to suggest to us, give us. We'll look at it. I know a number of people have spoken to me that even when we upload judgments on our website, we need to make it in such a way that a search engine should be able to bring out certain things that are needed as quickly as possible. The kind of thing you find with the current electronic law reports like Law Pavilion, where you can search for something and then you see a number of cases coming out and so on. We are open to doing such a thing once the suggestion comes in and we get in touch with our experts and we see how they can do it. If it's possible, why not? We are open to it.
Thank you, my lord. Mr. Bengapelo, you had a question.
The chairman of this occasion, the Honorable Justice Ejem Bieko, retired. The president of the National Industrial Court, Justice B.B. Kanyip, the eminent jurists of the National Industrial Court here present, and the honorable judges of courts of coordinate jurisdiction here present, Leonard SANs, my distinguished colleagues and ladies and gentlemen, I hope I covered the protocols. My name is Ngapelo. I'm a lawyer. I used to be one of those who came to the National Industrial Court and thought that we were going to bring this court down, and unfortunately, God did not give us to do. Objections were filed here and there, and Jamiu inclusive. We tried and tried our best, but then it was clear that God has made this court come to fruition. And we want to say a big kudos to the president. And I remembered Baba Adejumo will always tell us that, look, you better go and dust your books because we are going to have this court and nothing is going to change it. And we thank God. A quick one, sir. I find myself, unfortunately, leaving that part of the bar and going to the part of the bar that sits in offices and advising companies. And I found out that one thing that is critical here is the fact that with the wide and expansive jurisdiction given to this court, the criminal part of this court has not really been tested. I sit in a company where we manufacture, or we're a telecoms provider, and we try to connect MNOs so that the phones you and I use can work and all that. And I find out that because of the growing economic conditions, a lot of workers who work for either the companies or others have resorted to stealing some of these very important critical national infrastructure. Unfortunately, I found out that most of the ones which we refer to the police are tried at the regular courts. By regular courts, I mean state high courts, and sometimes, few times, the federal high court, because of the fact that the stealing arises from the stealing of telecoms facilities, which have federal high court coverage exclusively. Because these people are employees, I would like to know if there's a possibility that perhaps the police should be, it should be brought to the attention of the police that stealing arising out of workplace should be tried at the National Industrial Court. That is my first observation. Secondly, is the fact that there's a decision, there's one of the radical decisions of the Court of Appeal on the jurisdiction of this court, is the appeal in MT some purpose. In that case, the Court of Appeal stated that it is the National Industrial Court that has jurisdiction exclusively, notwithstanding the earlier jurisdiction conferred on the Federal High Court, on the claim of a ship laborer who would ordinarily had gone to the Federal High Court, get an injunction against the ship, and try to protect his wages from not being dissipated by the arrest of the ship. I'm not sure whether or not that decision is now pending before the Supreme Court. But the question I would like to ask, sir, is that it is possible that right now people will be constrained, lawyers will be constrained to come to the National Industrial Court, since that decision remains the current state of the law. My question that I want to ask is that, has this court put in place the necessary facilities that will aid the arrest of a ship when a ship worker approaches the NIC to get his wages? Because how it used to work is that because it is a general maritime claim, a claim made against that ship, which is a right in rem, is to arrest that ship as security to guarantee the payment of whatever claim is against that ship. From a worker's perspective, or from a laborer's perspective, which is now part of the NIC jurisdiction, I know that when you have an injunction against that ship, there are several steps you need to take with the shipmaster's register in Apapa and all those. I would like to ask that now that it is the law that you will approach the NIC, are there those factors that lead you to arresting a ship in the NIC and to enforcing that order at the National Shipmaster's Office? Thank you very much, sir.
Thank you very much.
I know that one of my colleagues has very strong views on that. Where is Justice Shobe? I'm sure you can answer him.
I actually did an article on that aspect of NIC's jurisdiction. The major point that were raised against the jurisdiction of NIC is actually that it might not be able to give administrative order to arrest ship. But if you study the Constitution very well, you will see that there is no basis for that argument. powers of court is distinct from jurisdiction. The powers of court are conferred by the Section 6 of the Constitution. And there are two types of power there in Section 6. The inherent powers and the statutory powers contained in statutes. The two types of powers are conferred on all courts. Once a court has jurisdiction, it has the power to make any type of order. Admiralty order is an aspect of the powers of court. Any court that has an aspect of admiralty jurisdiction can make any type of admiralty order too. Then, secondly, one thing that a lot of people did not notice about the jurisdiction of NIC are the provisions of the National Industrial Court Act. If you study the provisions of Section 12 to 19, it gave NIC a lot of other powers that the other courts do not have, which includes what you normally call these admiralty orders. There is virtually no type of order that NIC cannot make within the compass of the National Industrial Court Act. Then there is another aspect of the National Industrial Court Act that people do not generally know. That is Section 54, which actually says the NIC, so definitely we just borrow the rules of the Federal High Court to cover our admiralty jurisdiction for the time being till our new rule comes out. I think I've fairly satisfied you. So and if you want a copy of that, my article I will send to you. So you get a fuller details of the something. Okay. Thank you, sir.
Can I just add something? Two quick things. If you go to section, I think it's 54 or so, of the NIC Act, it's a section a lot of people don't even bother to look at, dealing with repeals, transition provisions, and so on. There's a provision there that says all the powers of a high court in any law, the NIC also have. The NIC has all powers of a high court once they are stated, so long as it has nothing to do with jurisdiction. Just go back and check that provision. That's number one. Number two, and it's a point I like to make, the ILO has the Maritime Labour Convention, 2006, as amended. What they did was to incorporate all conventions dealing with the maritime industry into one booklet. And this convention is very detailed in terms of the rights, privileges, obligations of seafarers. In fact, during the COVID period, many seafarers were caught up in jurisdictions other than their own, and they were denied access into the countries they were because of COVID. It was the ILO, through the committee of experts using this convention, that intervened. I always ask a simple question. Those of us who keep talking about maritime jurisdiction of the Federal High Court, maritime jurisdiction of the Federal High Court, have you for once thought of the justice of the case to the said seafarers that you are worried about? NIC is the only court constitutionally that can apply an international convention ratified by Nigeria. Federal High Court cannot, which means the Maritime Labour Convention cannot even be applied in the Federal High Court to start with. If you file a suit at the Federal High Court, you cannot cite that convention because the Federal High Court does not have constitutional mandate to apply it. But NIC has the constitutional mandate to apply it. So which court would you want to go to if you are saddled with a problem? I am not unmindful. In certain circumstances, I'm sure you were living witnesses I think it was even MBA through the office of J.K. Gazama, who went to Federal High Court to sue police over sacking the woman who was pregnant. And Federal High Court, I think it was Justice Eko, who said, look, you are the one who carried your hand and signed the contract, so you must live with it, and struck out the case. Even in my personal discussions with Justice Eko, I told him, you should have transferred that case to NIC, because in NIC, they can apply all the conventions dealing with discrimination, particularly those discriminatory against women that Nigeria have ratified. If you had done that, my predecessor is here. He did one some years back, but it related to a private sector employer where the woman was sacked because she was pregnant. He awarded, I think, 2 years or so salary as damages. So in this court, there are instruments you can apply to be able to get the justice of the case. But when you go to some other court, you don't get it. In my private discussions with a friend who had an issue and said he was going to file, not in NIC but in Federal High Court, I asked him why. He said, because I can go up to Supreme Court. In NIC, it has to terminate at Court of Appeal. And I said, but you forget that on questions of law, you can do case stated up to Supreme Court. And that's why on the issue of conflicting decisions, I am yet to see a lawyer who has done a case stated to Supreme Court on all conflicting decisions. Those who complain about conflicting decisions of NIC have not gone to Court of Appeal to have the issue rectified. Because I think it is within your right to say, Justice Kanyib did this, Justice Aroshabe did this, and they are conflicting. Court of Appeal, tell us between the two which one we should follow, or which one represents the law. In the same token, the Court of Appeal decisions, particularly the ones dealing with, take for instance, the question whether we have jurisdiction over torts in the workplace. There are conflicting decisions on that question. Right as I'm talking to you right now, nobody has gone to Court of Appeal to have, I said Court of Appeal, nobody has done a case stated to the Supreme Court to have that issue resolved so that we know whether NIC has jurisdiction over torts in the workplace or not. Coming to the question on criminal jurisdiction, it's neither here nor there. I always like to ask a simple question. If a worker were to take a gun in the workplace and shoot another worker in the workplace, would you file for murder in NIC? Would you? You see, our criminal jurisdiction, for me, is hinged on our civil jurisdiction. That's what the Constitution says. Whatever we have jurisdiction, civil jurisdiction over, if there are criminal components, you can come here. But because criminal responsibility or liability is not exclusive to us, it is concurrent. As I'm talking to you, I know there are a few criminal cases in some of our divisions, but they are predominantly issues relating to human trafficking, which by law is mostly, by statutory law, is mostly criminal, not even civil. Each time I have the opportunity to talk when it comes to issues of child labor, human trafficking, I make the point that majority of the statutory provisions make criminal penalties, not civil. So even when the Constitution gave us civil jurisdiction exclusively, it is rarely the case you will ever find a civil case in any of these areas. There are areas that are predominantly criminal. But because when it comes to criminal jurisdiction, it is concurrent, of course, prosecutors prefer to go to the other courts than to come to NIC. I know that Justice Ogbonnia, in respect of corruption, is of the view that ICPC cases, because they deal with public employees, should also come to this court. But again, you can't force a prosecutor to bring a case before you. The choice is their own. But because jurisdiction is concurrent in respect of criminal matters, it is not uncommon to find that they prefer to go to other courts than to come here.
Thank you so much, my lord. Before we proceed, we wish to recognize the presence of Justice Ada, Justice of the Supreme Court. Thank you so much, His Lordship. We will take some questions from that side before we go to our colleagues who joined us online. Yeah, some gentleman has been standing for a while. Yeah, it's you. Yes, sir.
Mr. Chairman, sir, the President of the National Industrial Court of Nigeria, my name is Tehemba Bashima. I practice from Abuja. My concern is about execution of judgments of NICN, not garnishee proceedings, but sell through public auction. I have a judgment of this court that orders for attachment of movable properties were done since December, and I've written several reminders, and the officers of this court seem not to know how to go about it, because they say do this, do that, and I've visited this court for over 5 times, written more than 3 reminders. So I don't know what this court is doing about execution of judgment through auction, public auction. Thank you, sir.
I know that so many auctions have been done in respect of judgments ordered to be executed, and some have landed us in trouble. As I'm talking to you, we have a court case against us in Port Harcourt where the wrong properties were attached and sold. We are facing that problem. So each time you come with issues like that, we're a bit careful. I, for one, I always like to know, when you say immovable property, did you identify the immovable properties? Because where you don't identify them, which is what led us into the problem we are facing in Port Harcourt, you go and carry. Yes, I know that there is what you call interpleader actions and so on, but the dangers usually is that when the third party now sues to say, look, it is my property you took, they join us. And because we work on a budget, we usually don't budget monies for court cases of such. So we are now compelled to defend cases, expend monies that are not necessarily budgeted for. And then secondly, I talk to my colleagues. Majority of petitions we find against judges today are dealing with post-judgment applications. And I've urged my colleague, and I'm saying it publicly here, to be circumspect in granting those orders, because lawyers have a way of not even bringing the true state of affairs before you. The, unfortunately, sorry to say it, incidents of foreign shopping, we've seen instances where you get a judgment in Abuja and run to Port Harcourt to go and register it in the name of enforcement. And what kind of enforcement? Garnish. And against who? Banks that you could as well have done them here in Abuja. So we're a bit careful when you bring up some of these things until we are certain that we are not in the line of trouble. We stay action and observe.
Okay. Thank you very much, my lord. So we have people online, also part of this event. So we would like to take 1 or 2 questions from the participants online. one of the participants, his name is Abdul Aziz Mohammed. Yes, Abdul Hafiz Mohammed, sorry, is making an observation with regards to the use of the pretrial proceedings in the National Industrial Court rules, the pretrial provisions, sorry, and is asking why the court does not, in his own opinion, the court doesn't utilize it that well, so that the pretrial conferences can be used to streamline issues for trial, encourage settlement, and avoid unnecessary delays.
Incidentally, if you read the rules carefully, the pretrial conferences are not court-driven. It's supposed to be consensual between the parties. They are the ones who drive it. And the moment you have lawyers who are not keen about driving it, there's no way the court can compel you to do it.
Okay, my lord, but just for my own education, in regular courts, the court will adjourn for pretrial proceedings.
Courts have their rules. Go to the NIC rules first. That's the starting point. It's what the rules say. Take, for instance, the question of mediation. In our own rules, until issues are joined, you can't send parties to mediation. Yes. In other courts, you start mediation before you even join issues. So everything depends on the rules of court. I always tell people, start with the rules of the court you are appearing before. That's the only way you can argue your case, good or bad.
Thank you very much, sir. The other question is on using Zoom proceedings, especially for the benefit of counsel that are outside jurisdiction. The court does Zoom proceedings, but is there an effort to institutionalize it, make it almost standard, especially where distance is a challenge? I think that's a question here.
The COVID was what gave rise to virtual hearing. I've had letters written by counsel to direct judges to do virtual hearing, and I have replied that to do or not to do depends before. If you want a virtual hearing, you apply to the judge before whom you are appearing, and it is the judge who will agree that virtual hearing should hold. It has nothing to do with court. The only thing I know as a head of court I have done is that those judges who are handling divisions where we don't have resident judges, I have given standing instructions that they do those cases virtually. And this, like I said yesterday in my speech, is for security and other structural reasons. This thing about judges moving up and down does not really say well when you factor in questions of security and so on. So if you want a virtual hearing, apply to the judge, of course, taking into account the opposing party. If it is to take a witness, well and fine. But again, you know that as is part of the problems of developing as a country, there is no assurance you will get a seamless hearing. You are going to have breaks. The few occasions I did virtual hearing here, I have to use two different devices, the phone, the computer, just so that if internet in one drops, I can continue with the other. On one occasion, I was doing one and the computer went off, and it had to reboot all over. We wasted time and so on, but these are all part of the things with underdevelopment. But like I said, if you want a virtual hearing, apply to the judge. He is the one. The practice directions have permitted it. So you apply to the judge and you do it. But let me take this opportunity to implore once again. The trial on record proceedings should be one of the easiest ways by which you can complete cases quickly. I don't know why counsel have difficulty agreeing to it. I know the rules say the parties must consent, and it is always the case that a party who is not very comfortable with his case and wants to delay proceedings will not give you the consent. But this has to do with the bar. If you want quick dispensation of justice, there are proceedings that allow you the opportunity to do that. And if you read the provisions as to trial on record, they are very specific. You dispense with oral evidence and use the documents as evidence and as given. Employment disputes, I always tell people, are predominantly documentary. You are looking for errands pay or backlog of salary. They are all hinged on interpretation of documents as to entitlement and as to quantum. All of this, I sometimes have urged that go back and look at the respective decisions we make. Even when we spend hours with witnesses in the box, at the end of the day, when you read the judgment, I want you to be conscious and ask yourself a question. What part of this judgment would not have been given but for the oral testimony? You will discover that in the main, the oral testimony is just lawyers trying to show their skills, how to cross-examine, how to do. Very little of it goes to the actual outcome of the decision at the end of the day. Because predominantly, witnesses cannot interpret documents. That's the function of the court. So when you see lawyers telling witnesses, read paragraph X, and you are like, why are we going to say, no, the court said we don't dump documents on you and so on. I'm like, you do that with chieftaincy matters where documents can easily be faked. You do that with land matters where the stakes are high. You do that with election cases where the stakes are high. You come to an employment case where the relief is 500,000 naira, 2 million naira, and so on. I don't know who wants to go through faking documents to be able to make a point in respect of that. So, the point I'm trying to make, sometimes we as lawyers, even when we apply rules of evidence, we do it out of context. The Evidence Act is a 1948 legislation. Forget the fact that it is put 2011. It's a 1948 legislation. And the provisions, particularly those ones that are not touched, are provisions based on the society of 1948. And you cannot tell me that 2024 society is the same thing with 1948 society. So if you cannot be able to read these rules in context, I don't know why we are lawyers.
Thank you very much, my lord. We have a question from Mr. Ajay Monday, the chairman, MBA Buhari Emeritus. Sir, do you want to take your question now?
My noble lord, may I, with your kind permission, on the protocol already established for want of time. Mine is not of question per se, but it borders about administrative activities of this court in respect of compilation of records for appeal. Whether we like it or not, some of us are in silence, and we are all affected. Because anytime we approach this court, we are here with some poor workers who have suffered one in the hands of their employer, and again, on getting to the court, in one way or the other, the judgment is not in their favor. And reluctantly, with their poverty, they still want to proceed higher. But anytime we approach that section for compilation of that record, we discover that it is a difficult task for these poor workers to meet up. And in regular business center, we know what it takes to get some of this in. I remember some years ago, when my Lord Justice Adejimo was in charge, there is a way they subsidize this thing for these poor workers. The subsidies, I may not get the accurate whatever, but the system in the courts are working. The photocopier, everything are working for lawyers. Even if you want to photocopy law report, they do it for you free of charge. That was then. I'm also aware that there is fund.
There was money then.
Yes, my lord. Now that there's no money, we want to appeal for subsidy so that the poor man will not go back home and take law into his hand because of level of frustration. I want to appeal that my lord should waive in. If there can be a seal on the issue of record compilation, so that when we are coming, we know that this is a seal, not for us to come and be negotiating. Today, they will say 1 million. No, I'm not saying that's what I'm just using as an example. And tomorrow is 500. I'm sure my leader, SCN Okutekpa, is also aware what he suffered in court in election related. So, my lord, we are begging that my lord should waive in so that this will be better. And secondly, my lord, this court is created for purpose of helping the poor workers, one of the conditions. Now, my lord Josiah Adejima will understand what I'm talking. Somebody from Arobo in Ondo State, for them to access Akure, if you are not taking care of time, they will spend almost close to 2 days. Is there a way that this court can borrow a leave, just like Court of Appeal, by going to some of these judicial divisions, close to these people, and sit maybe just for a week and cover those spaces? Because Court of Appeal at times will go to Maiduguri and sit for weeks and cover all those people before they will come back to Jos then. So I'm appealing if the court can do that so that everybody will be carried along. Because this idea of having the courts in capital city is expensive to get the lawyers and hotel and rent for these poor workers who have suffered. My lord, I'm appealing that if the court can waive in this regard, we appreciate. Thank you, my noble lord.
The court does not have the money to do all that. And once there is no money, except you want to draw blood, it's beyond me to assist. That's just the plain truth. If you know what we are going through to keep afloat, we did a budget on the basis of diesel being 300 naira per liter. Before the budget was released, diesel had gone over 1,000 per liter. What do you want me to do? What do you want me to do? The original conception of the NIC was for it to be a final court. It's you lawyers who went to Court of Appeal, went to Supreme Court and said we are flexing muscles and want to be like Supreme Court. Every year that I speak, I said in labor disputes, time is of the essence. And I always repeat this ILO adage. It's better to have a bad judgment quickly than a good one too late. You said no, you want appeal. Supreme Court gave you right of appeal. Now you say you don't have money for appeal. And you want me to subsidize. You see, the founding fathers knew what was in issue when they said, as much as possible, terminate at NIC. I am not saying that we deliberately give wrong judgments. No. We try to give good judgments. But in as much as we try to give good judgments, we are human beings. There's the issue of infallibility. We are not perfect. Once in a while, we'll give a decision that you don't like. But you as a litigant must learn to also accept the outcomes of decisions. You can go up to Supreme Court. If Supreme Court rules against you, won't you accept it? So why does it make a difference that it is NIC that decided and you don't accept it and you want to go on appeal? When Supreme Court decides, you don't say we want to go on further appeal. I tell people, always watch out and be careful for what you ask for. If NIC were a final court, as it was originally intended, you wouldn't be talking about money to go on appeal, would you? But no, I did a paper in 2014 in MBA conference in Owerri, and I made it very clear that the stakeholders, the paper was the finality of NIC decisions. And I said, the stakeholders, and by the stakeholders, the social partners, there are three, government, employers, and workers. None of them complained that NIC is a final court. It was lawyers who complained, and I asked why. Because they want to be SANs. They are looking for cases. So, MBA chairman, you can't eat your cake and have it.
Thank you, my lord. Max has a question.
Thank you very much, the President of the Court. I stand on the well-established protocol. My name is Max Ikongbe. So, sir, I want to ask a question about elevation of judges of the court and sometimes the dislocation that causes to pending matters. So I have the interesting scenario where we had a matter we had already filed final addresses, and the judge in question was elevated. We were informed that we should go ahead, file our addresses, and that the new judge the matter was assigned to will proceed to adopt our addresses and deliver judgment. So I'm just wondering, you know, from a constitutional viewpoint and in light of Supreme Court decisions, whether that can be done, and perhaps if there's a context that we are not seeing from perhaps the NIC Act or the NIC rules. And then secondly, sir, on the issue of appeals arising from decisions of the NICN, because my Lord Justice Eko GSC retired is here, perhaps we would also get the benefit of his views on the case of Skybank versus Iwu, where my Lord was on the panel that gave that decision. There's an interesting portion of that decision arising from the judgment of Akas GSC, where he opined that in his own opinion, even though appeal should lie from decisions of the NICN to the Court of Appeal, but that for matters arising under Section 254 C sub 2, that is issues of international best practices, that there should be no appeal, that the NICN is the first and the final court. So I'm wondering, sir, if perhaps that there shouldn't be a rethink of the position, and whether Skybank versus Iwu actually determined fully and finally that there could be appeals to the Court of Appeal from the NICN, particularly on issues arising on international best practice under Section 254 sub C sub 2. Thank you very much, my Lord.
I must confess, I really didn't get that question. I don't know whether any of my colleagues got the question and wants to bail me out.
Yeah. Mr. President, perhaps I can draw your attention to the first part of the question, the issue of elevation of judges of the court. So we have a scenario where we had already filed final addresses. The Honorable Judge was elevated to the Court of Appeal, and we learned that upon reassignment of the matter to a new court, the new court has asked that we just come ahead and adopt our addresses and the court to proceed to give judgment. We are wondering, you know, so I was wondering whether that would align with...
Maybe they try and wait for Court of Appeal to tell us whether we are right or wrong.
Most good.
You see, we have provisions in the rule that say, although it deals with transfer of judges, which says that parties can agree. The key is parties agreeing. Because if parties agree, they will not make that an issue on appeal to start with. Now, it says that parties can agree to continue where the former judge stopped, which means even evidence elicited and whatever will stand. Now, part of the arguments in favor of trial de novo is that you didn't have opportunity to look at demeanor of witnesses. And I ask a simple question: which employment case is hinged on demeanor? Except for workplace injuries, where the evidence may be complex, where, okay, demeanor may be necessary. All the other areas of employment litigation, demeanor plays little or no role whatsoever. Everything is documentary. So, I don't know whether on that basis, if you go to Court of Appeal and you explain this to them, they will accept it. I'll give you a simple example. We have this thing about You know, there's a Court of Appeal decision that says because every employee has a separate contract, it's an old Court of Appeal decision. Every employee has a separate contract. They cannot file together a suit. They must file individually, even though the ASU 47 decision in Ilori, Supreme Court said no, expedience can allow you for them to come together once the cause of action is the same. Now, we have this provision where there were a number of cases, similar, about 10 of them. And we agreed with the parties that we will use one as a test case. Because the moment you decide one, every other thing falls in place for all the others. So we did that, and I gave the decision in one. Incidentally, that agreement was not endorsed in the record of proceedings as an agreement. But when writing the judgment, knowing that there was that agreement, I endorsed it on that parties had agreed in the judgment and so on. Of course, one of the parties now made that an issue at the Court of Appeal. I was then in Lagos. The Court of Appeal said, this decision that I decided was very good. They upheld me. But in relation to it applying to these other ones, they said no, because there was nothing in the record of proceedings showing that there was agreement of parties to adopt that procedure, that the decision in one will abide all the others. And then they ordered for retrial of these other cases. Of course, the justice was my friend. So we discussed privately. He told me, look, we like your decision, but we had to overrule you and ask for a trial and so on. I asked a simple question. Now that you said the decision that I did was good and you upheld me, tell me, what will any other judge go and be retrying? The issues are the same. The circumstances in which they came to court, the same. So if you upheld me in this and you ordered retrial, don't forget, by upholding me, it is now a Court of Appeal decision, not Kanyip's decision. Which judge of NIC will go against what you have approved? Sometimes we need to be, that's why for us as a court, we like to emphasize that we are not a technical court. Informality, flexibility, speed are guiding principles. If Court of Appeal, for instance, notes that, there is no way it will say it is ordering retrial. It will simply, in any event, Court of Appeal has provisions in their act that allows them, if the evidence is available, to put themselves in the shoes of a trial court and decide the matter. Court of Appeal could as well have said, because we have upheld this decision and the issues here are the same, we are now putting ourselves in the position of a trial court and making it to apply. They could have done that.
Thank you, my lord. Sorry? Well, Max, do you want to ask your second aspect of the question again?
Yes. So the second part of my question, I'm wondering if my lord ECO GSC would oblige us his view on the judgment of the Supreme Court in Skybank versus Iwu that opened the floodgate to appeals from the Industrial Court to the Court of Appeal. My lord indeed was on that panel, and Justice Akas, in his own contributing judgment, not the lead judgment, made a point that, you know, when it comes to appeals under Section 254C, sub 2 of the Constitution, that is the part that gives the NICN jurisdiction to apply international best practices, that in that circumstance, then there will be no right of appeal to the Court of Appeal. None of the other justices in the lead judgment or in the other contributing judgment actually made a specific holding on that point. In fact, it is so funny that the Law Pavilion report of the decision does not cite that there was a dissent, but the NWLR report on that decision says Akas JSC dissented. But if you read Akas JSC's judgment, he never used the word dissent, he never used the word disagree, he never indicated that he did not agree with the lead judgment or with the other concurring judgment. So I'm wondering, that area seems to be a gray area that, when it comes to international best practices, there should be no appeal from the NICN to the Court of Appeal. Thank you very much, my Lord.
It's been a long time. So whatever has a beginning has an end. But what Ikongbe was saying just now, Tapias is calling me as a witness. And Akas also is not here to defend himself. The issue of how the authorem patem will arise. But if in the Skylark case, there is one particular provision of the Constitution that we used. It says, provide, I can't precisely now locate, but you read that judgment, you will find that constitutional provision that says, provided is not a final, it shall not be the last court. That's why we say, okay, NIC has decided, but in view of this constitutional provision, maybe the Supreme Court, there should be a right of appeal, and the Court of Appeal, the final decision. And so on and so. I don't have, since I retired, I don't read anymore. and there was another person called me a witness today, Ukutepa. He said, for 5 years, I've been hard on him and all. Yes, for 5 years, he was repeating the same error, and for 5 years, we were bringing him back. The issue was, all we were emphasizing, for every lawyer, your best tool is, and the judge, be a master of the procedure, whether civil or criminal. What I advise all new judges is go and be a master of the procedure, civil or criminal, so that when you are on the you are presiding in a matter, you can say, have you read this provision? Look at order so and so and so. And so we're calling him to order. But when he became a master of the ropes and started mastering the criminal procedure and civil procedure, it helped him. And then there was, there is this issue of one question too many in one matter. A lawyer was trying to overkill the witness, and the witness just remembered, he shook himself, and then he answered. The answer was the killer. It was a question, one question too many. And many lawyers are guilty of it, over cross-examining. Now the NOMSO, Ekanem, and to some extent Ukutepa, on the current, on a judgment from the Federal High Court on whether, the issue was whether a court can restrain the performance of a statutory duty. The matter may be sub judice. It's already on appeal, so it's sub judice. I will not comment much on it. But when you have such issues, first of all, find out whether the trial court has jurisdiction over that matter. The issue there at the Federal High Court was a pre-election in a local government. Find out from the Electoral Act or from whatever, whether the local government, whether the special jurisdiction given to the Federal High Court in addition to Section 251 of the Constitution covers such election to local government. I know in some opinions, the Supreme Court said the local area council election in the Electoral Act is not synonymous with the local governments at the state level. I say it's sub judice, so I'm not going to talk about it. I say it's so long. I think it is time to go, and I want to ask My Excellency, the previous president of this court. Let's hear one or two words of advice if he has.
Please, order from the. Well, we have said today, and I would like to believe I learned a lot of things, and we still have a lot of things to learn. Both the president of the court and judges of the court, they believe that learning is a continuous process. It's the totality of what happened to you from when you were born to when you will die. I commend you for the way you are steering the chief of the court and the judges, as well as the staffers. I wish you more of this. And to all of us who are lawyers, I don't have much to say. I've said a lot for over 30 years, so thank you.
You know, both of us are retired. I think we have expired, is it? We have a current jurist, and we have a admin of the Supreme Court. We might want to hear from you.
Permit me to sit on the existing protocol. My Lord, the only thing I'm waiting for is my certificate of attendance. Thank you.
Well, I think on a cautious note, he sat on the existing protocol, but he didn't find out whether whether you sat on the protocol and broke it. And I have my learned brother, Justice Ada of the Supreme Court. Any comment?
Well, thank you, my Lord. I can equally sit on existing protocol. Well, I'm happy I made it here. We're so busy in the court this morning. When we rose, I looked at the time. I said, well, let me step in and see at what point I can still benefit from this gathering. It's been a useful time. Many things were raised, and a lot we have taken notice of. And I want to let you know, my own is to just give you a goodwill message. And the goodwill is the fact that NICN, since inception to date, has lived up to its expectations of many of us. And I believe that with our good efforts, way forward, we can do better. And the other thing I must advise is that being labor-related, we should try as much as possible to simplify things for our suitors, the litigants, because some of them have already been beaten in the rain, and they are coming for rescue. So if you put more pressure on them, then the whole purpose and the whole idea will be defeated. So let us work towards simplifying things and reducing the burden of those who have been beaten and are running for help in industrial court. And I think a new year has come, and this new year also will bring new ideas. And we thank God for the experience of our senior brother who said he has retired, but I see him as somebody who can never be tired, even in retirement. He's always refiring and putting fire. So let him continue. Thank you, my Lord.
All right. I have taken over as the proceedings, so you can step down now.
Thank you.
So, and from what I have, we have item 8, I hereby call on Honorable Justice A.O. Obaseki Osage to perform her statutory duty without any injunction.
Good afternoon. Good afternoon, my Lord. Good afternoon, my Lord, the chairman of this occasion, Honorable Justice Ejembi Eko, JSC, retired but not tired. My Lords of the Supreme Court, here present, Honorable Justice, I don't want to make the mistake of seniority in the Supreme Court, so I will just say, my Lords, Justices of the Supreme Court present, Justice Ada and Justice Adumian. I apologize if I have put it the wrong way. I am not too sure who is senior in the order of swearing in. My Lord, the retired immediate past president of the National Industrial Court, Honorable Justice B.B. Adejumo, OFR, and my Lord, the President of the Court, Honorable Justice B.B. Kanyip, OFR. I also greet at this time all the senior advocates present here and say, as we bring this event to a close, I would like to extend my deep appreciation on behalf of the President of the Court and the Court in general. To, first of all, my Lord, the chairman of this occasion. For gracing this occasion, we do not take it for granted, my Lord. We are honored to have had the opportunity to learn from your fount of knowledge and wisdom at this occasion. My Lord, we know you are retired, and we know that you are not tired. And we pray, my Lord, that whenever we call you, my Lord will be willing to heed to our requests, to come and bless us with his fount of wisdom. My Lords of the bench of the Supreme Court, I cannot express or rather words are not enough to express my appreciation and thanks that you have taken time off your very busy schedule to come and spend the whole day with us at this public lecture and bench bar forum. My Lords, we thank you. At this occasion, I cannot fail to extend our deepest appreciation to the guest speaker, who unfortunately has had to leave. Mr. Segun Adeniyi is a prolific writer. But I never knew he was such a prolific scholar. At the time he began, I was quite sure that he had attended a program at the International Labour Organization Training Institute in Turin, because of the way he marshaled out the ILO conventions, and then he went into the jurisdiction of this court. And then, of course, he showed us his scholarly attributes and pursuits when he said he went to the library of the NIC to continue to do the research. It was simply humbling to hear that. And so, our immense thanks goes to him for the insights that he shared, the new perspectives that he has brought to deepen labor justice and labor jurisprudence. Mr. Segun Adeniyi, I say thank you on behalf of the courts. The learned senior advocates who are here present, I say a big thank you. You have been here from the beginning, and you are still here at this time. We thank you very much, because we know that for you to leave your chambers and spend virtually the whole day here is an extension of the honor that you have in you and have accorded the courts. I say thank you on behalf of the courts. The representative of the president of the NBA, she has been here with us since yesterday. I remember her name, Anima Shaun. Yes. We thank you very much. And we ask that you extend our thank you and appreciation to the president of the NBA. To all those who have given goodwill messages, the president of the Nigerian Labour Congress, the president of the Trade Union Congress, the president of the Chartered Institute of Personnel Management, the NBA SBL Committee, the Section on Employment and Labor Relations, we say thank you. And to all the attendees, we cannot but acknowledge your presence here with us from the beginning up until this time of bringing this program to an end. We know that without the attendees and the questions, this section or this program today would not have been as exciting as it has been. We have learned a lot. The discussions have been very deep and engaging. And we thank you all for being here up until this time. If you hadn't stayed, this hall would have been empty. But it is not, it's still very full, which shows that there's still so much, you're still expecting so much. But because of time, we have to bring the whole occasion to an end. And then I cannot forget the anchor, Mr. Folabi Kuti, SAN. He's always ever ready to lend a hand, to assist, to run around whenever he's called. Mr. Kuti, I say thank you on behalf of the court. For the committee that has put all of this together, the sleepless nights, I say thank you. For the management, to the management and staff, thank you. To those who have been working tirelessly behind the scenes, those who are in charge of the audio, of AI, those in charge of AI for this occasion, the caterers, the hostesses. I say a big thank you to every one of you. As we close and as we go home, I wish every one of us journey mercies. I pray that God will bless each and every one of us and every one of you who have come from far and near. And at this time, precarious time in the country, and particularly for the judiciary, I ask that the judiciary and all the judges of this country, you remember all of us in your prayers. Remember particularly the judiciary, that God will enable the judicial officers of this country to live up to expectation, the expectation of delivering justice. And we cannot do it without your prayers. We cannot also do it without the support of the bar. So at this occasion, I thank all members of the bar, the inner and the outer bar who are still with us, and ask that you please remember that you are also, we are in the same constituency, and we need your help to take the country to where it should be in the Committee of Nations, particularly when it comes to justice delivery. I say God bless the National Industrial Court of Nigeria. God bless Nigeria. Thank you.
A round of applause for the Honorable Justice Obaseki Sage. Well, this effectively brings this program to an end. We will take the national anthem, but just to inform us that the court has been gracious enough to provide cocktails and lunch. And I'm told that immediately after this, you can move to the hall next year for the cocktail. So kindly make time to attend that as well. So at this junction, my lords, ladies and gentlemen, we'll kindly rise for the national anthem to bring this in.
Nigeria, we hail thee, our own dear native land. Though tribe and tongue may differ, in brotherhood we stand. Nigerians old and proud to serve our sovereign motherland. Our flag shall be a symbol that truth and justice reign. In peace or battle honored, and this we count as gain. To hang on to our children Thank you.